The Honorable Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Ms. Frazier, I think there are a number of counsel on right now beyond the counsel that are arguing.
Okay, Judge, your view settings then need to be changed.
They're all on mine also, and I thought we had ours fixed.
It actually, it's because they are all on camera right now. They will go off camera and only arguing counsel for the first case will appear. So,
all right,
counsel, if you're not arguing the first case, if you would please turn your camera off. Thank you.
Okay, I think we're ready then. You did the cry already then, I think?
Yes.
Okay, all right then, we can proceed. Are you gonna show the clock? All right. The first case this morning is Rodriguez versus Rich, 24-2163. Counsel for Appellant, if you would make your appearance and proceed, please.
Good morning, Your Honors. My name is Heather Burke, and may it please the court, I represent Plaintiff Appellant Marty Rodriguez and Joshua Rodriguez. I would like to reserve 3 minutes for rebuttal. The Family and Medical Leave Act 29 USCS Section 2601 was enacted by Congress to entitle employees to take reasonable leave for medical reasons. In enacting this law, they recognized that there was inadequate job security for employees who have serious health conditions that prevent them from working for temporary periods. On the night of February 20th, 2020, after working a full 8-hour day plus 15 minutes of overtime, Jeremy Rodriguez Ortega was hospitalized for emergency treatment by his FMLA qualifying condition. As a direct result of his hospitalization, Jeremy was unable to give notice of his need for leave within 30 minutes of his shift the following day. 29 CFR 825.303C provides that when an employee is receiving emergency medical treatment, he is not required to comply with employer call-in requirements. However, on the first day he was absent, Jeremy's family informed Defendant Rich that Jeremy had been hospitalized, giving Defendant Rich notice of Jeremy's need for FMLA leave. 29 CFR 825.303A provides that a family may give notice. There is no requirement under the law, however, that family members must give notice at all, let alone by a certain time in the day. And the court,
Ms. Burke, can I just interrupt you for a quick second here? Yeah. I just want to make sure I understand the scope of this appeal. As I understand it, there are only certain claims that are at issue here now, right? Relative to what was at play in the district court. For example, you're not challenging that terminating Mr. Rodriguez was not, well, let's see. Let me just state it otherwise. Why don't you tell us what claims you perceive to be present on appeal now?
So in this appeal, the primary substantive issues are the FMLA interference and retaliation claim, as well as the issue of whether or not defendants admitted the allegations in plaintiff's complaint when they failed to timely file their answer brief.
Well, just to be clear, what specific factual instances are at play in the retaliation and interference claims? I mean, was there a number, like there were 2 instances related to leave? And so what specific instances are you challenging here?
So the instances happened, there is a 6-day period in February of 2020 when Mr. Rodriguez Ortega was hospitalized. And then there was a second incident, again, where he was hospitalized in May of 2020. And those are the 2 primary periods that we're alleging for the FMLA interference.
Okay, that's helpful.
Now I have one question, Ms. Burke.
Sure.
You only have one appellant here, correct? Even
That
though
is
you've named two appellants in your pleadings.
so that you are correct, Your Honor. And when I filed this notice of appeal, we were intending to only appeal the FMLA issues. And because Joshua Rodriguez does not have FMLA claims, he was not named in the initial appeal. He's become more of a interested third party when we added the appeal of the motion to strike and the issues related to the failure to deny. But he is not a technical appellant, Your Honor. You are correct.
Okay, thank you.
Okay, I just have one clarification on your response to Judge Holmes also, and that is, I thought you said that that issue in this appeal were both your retaliation and interference claims, but your briefing only discusses the two interference claims that you just now mentioned. And I think it was noted in response that you seem to have abandoned your retaliation claims. So I just want to confirm that you misspoke there and that you aren't continuing with those retaliation claims.
I think arguably the retaliation claims could have been abandoned, but they're also dependent on these issues of whether or not notice was properly given. Because if notice,
well, you have to argue them. We've got to argue them on appeal. They're separately considered and decided by the district court. They're all lumped together and they have a different set of elements for sure. So I'm trying to clarify what our issues are here. And it seems to me you're suggesting that you only argued the interference claims, the two interference adverse instances.
well, there are multiple adverse interferences in two separate periods, because each time that Jeremy was marked AWOL is itself its own discrete adverse event, because each time he was denied the use of paid leave, he was damaged.
Okay. Now, the district court decided the interference claims based on the third prong, the causation, found there was a lack of causation because Jeremy was, in both instances, marked AWOL because of, at least for some part of that time, and because of his failure to provide notice under the company policy. You didn't raise this issue about what I call the unusual circumstances regulation, which is 29 CFR 825-303 that you mentioned a minute ago, section C. It didn't seem to me that you raised that issue below at all, and yet this seems to be your primary issue on appeal, is whether somehow they acted in violation of that regulation.
Your Honor, we've cited 29 CFR 825.303C.
I believe you cited it. But there was no argument about this, and that's different.
We argued that he was incapacitated by his medical treatment, which are the unusual circumstances. We may not have used the phrase unusual circumstances, but the unusual circumstance is clearly that he was incapacitated by emergency medical treatment.
Well, isn't that, I'm sorry. Go ahead.
Oh, no, go ahead. I'm sorry.
Well, I was going to say, isn't that also relevant and provided for in the company's policy that they found that he violated, because it provides that basically, I think it says that you have to give notice unless it's not practicable, which would essentially have been your argument, which the district court rejected, that it wasn't practicable.
Well, the district court rejected that it wasn't for unclear reasons, while also finding that Jeremy's family must have given notice. Now, the district court, for some reason, believed he was absent on the Thursday first, but he wasn't. He worked a full day, including 15 minutes of overtime, and then went to the hospital that night. He was absent for the first time on the Friday, and the Friday is the day the family gave notice. So they had noticed the very first day of his absence, and it's important to note that there's nothing in the record to suggest Jeremy had ever been absent before without giving notice.
Notice the first day, and you go back to what you just said, because you mentioned notice the first day, and yet notice the first day of an absence is not sufficient, is it? I mean, once you get out of the hospital, you don't get to just keep stretching that notice, right? Isn't that the problem here?
He was still in the hospital, Your Honor, for 3 days.
Are we talking about May or February?
In February, Your Honor.
Okay, what about May? Did he even seek FMLA leave in February? Or in May? Did he seek FMLA?
Yes, he did. On his way to the hospital in May, he invoked FMLA in a text message. And it's a question of fact whether or not that was sufficient to give notice of his need for leave when he became incapacitated. Now, it's important for Your Honors to understand that Mr. Rodriguez-Ortega's health condition resulted in a flood of toxicity to his system, which created confusion, it created instability, it created nausea and general incapacitation. He was unconscious for a lot of the time. Now in May, we'll remember that the pandemic had just begun and hospitals were turning away people that weren't critically ill because of the risk of COVID. And Mr. Rodriguez-Ortega was obviously very high risk for COVID complication. So he would have normally been admitted the first time when he went to the hospital in May, but because of the risk, they sent him home again. Eventually, during his period of absence in May, he was actually admitted to the hospital for several days. He was in and out of the hospital, I believe, 3 times during his period of absence in May. In February, he was also hospitalized immediately. This was prior to the pandemic. He was hospitalized immediately and then incapacitated by his painkillers and his general malaise from his treatment, because there was really not much they could do for him for this. Once his kidneys started failing, they could help with the toxicity. He eventually went on to dialysis. But even then, he was regularly incapacitated by these symptoms. Again, his notice was given on the Friday of the February leave, but yeah, he was marked AWOL that first day. They knew he was in the hospital. They had actual notice from his family and they marked him AWOL anyway. They then on Monday, Tuesday, and Wednesday of the following week properly designated his leave as FMLA qualifying, but then Thursday, for some reason, decided 3 hours of that day he was AWOL and 5 hours of that day he was FMLA protected. Then the following day, the Friday, a week from his first hospitalization, he was marked AWOL for the entire day. There's no rhyme or reason, nor is there anything in the record to suggest that any of those days they got more or less notice from him. They knew that entire week, it's a 6-day period, which is inherently reasonable for a hospitalization of this nature, for him to be absent. He was absent approximately a week of work. He had more than enough paid leave to cover it. He had been a state employee for 18 years and earned an enormous amount of paid leave, which he could have used for those absences and did use for the ones that were marked FMLA protected. He was denied the use of his paid leave for the AWOL designated times. And when he returned to work, I
just want to make sure that you get to what I see. I think you're only really making 2 arguments as I can see it on appeal. And one was this CFR that you cited and discussed, an unusual circumstances issue. And then you seem to be challenging the district court's finding of facts, as I recall, about whether he had any responsibilities, whether his work responsibilities were removed, which the district court said that they were, but then the district court also said he found that he did actually have some assignments of work responsibilities. And so you're challenging that, but I question, if you're not arguing the retaliation claims anymore, I don't understand quite what that issue goes to. Why is that fact material if it is controversial?
Well, at the time we were doing this, we still had our Human Rights Act claims in this case, which were retaliation and discrimination for his serious medical conditions. And therefore, the fact that his job duties were stripped, even if we take FMLA retaliation out, is still important to the issue of whether or not he was discriminated against.
Can you assume for a moment that you're correct and that there is a fact issue on that? There's a controversial fact on whether his job duties were taken away. Can you explain to me how that's relevant to the interference claim?
It's relevant to the interference claim because that itself discouraged him from invoking his FMLA leave in May because he was told explicitly that he could not retroactively invoke his FMLA leave even when he was in the hospital, and that therefore this chilled him from wanting to take FMLA and chilled him from clearly stating that he had been in the hospital the next time this happened, all of which are questions of fact.
Ms. Burke, but chilled is language of retaliation. I mean, that's language of a claim that I at least understood you to tell Judge Moritz is no longer on the table. Do I misunderstand that statement? And if it is no longer on the table, then the fact that there was some chilling effect really is not relevant anymore.
Well, it remains relevant because by statute, interference is obtained when you discourage somebody from using their FMLA leave. So chilling somebody is the same thing as to discourage them. And that is a factor in an FMLA interference claim.
And what in that chilling would have related to what? The May incident or the February incident?
Well, both, because he was denied leave for February and then he was misinformed about whether or not he could invoke his FMLA leave in May and told that he could not because he had not complied each and every day with the call-in procedure. And that is simply not the case under the law.
But I guess on the timeline, when did the alleged stripping of duties take place?
When he returned from the February leave. Your
Okay,
Honor.
so it would have been so any chilling after the stripping of duties would have occurred after February, right?
Correct.
Okay.
Well, and as I understand what you're still saying that he was chilled or essentially prevented because he was told he couldn't retroactively take this FMLA leave. But I'm still trying to get how that connects to this whole issue of the fact that he did or didn't have work responsibilities. Did somebody connect the dots there? Did somebody say, well, you can't have FMLA because you haven't been working or we took your duties away? I'm trying to figure out why that's material.
Well, as I say, it's material for our Human Rights Act discrimination claim, and it's material for the fact that he was made to feel, he had no job duties while he was there, and that becomes relevant when they say that he wasn't doing his job duties, and that's one of the reasons for his termination was that he wasn't doing it. But if he had no job duties to do, then that's not possible.
Okay, thank you.
All right. Ms. Burke, your time is over, but I'll give you a minute of rebuttal when we get to it. Okay.
Thank you, Your Honor.
All right. We'll hear from Appellee now, please.
Thank you, Your Honor. My name is Paula Maines, and I represent the defendants, the New Mexico Department of Health, Ken Lucero, and David Rich. May it please the court. This appeal involves a career labor relations analyst at DOH whose job it was to write formal disciplinary notices applying facts to policies to support just cause for formal discipline. Mr. Jeremy Rodriguez Ortega was very familiar with the leave policies of the department because it was his job to assist the agency to enforce them. In spite of repeated efforts to have him comply with the requirement to notify the department 30 minutes in advance of a scheduled shift anytime he was going to use his intermittent FMLA leave and be absent from work or was not ready for work, he did not do so. In the opening brief of the appellant, page 24, he says in his career, he always complied with notice requirements when needing to take leave. That is until 2 times in February and May of 2020. He failed to provide notice of his absences when he was working in the office and when he was working from home during the pandemic. On the dates when he did not work and did not call in, he nonetheless entered his time into the state's time capture system as hours worked. All of the time entries were made by him. All of the dates discussed by Judge Moritz just now with counsel for the appellant were dates when Mr. Rodriguez Ortega entered his time as time worked that day. He admits that
what do we make of this notice issue that was raised regarding his incapacity in the fact that his family responded. In other words, they did on the Friday after the Thursday provide notice that he was unable to earlier give the employer notice.
Well, Your Honor, what happened on May 4th, and it's in the record at page 283 of our supplemental index, supplemental appendix, that he sent a text message, and I'm going to read it. I think it's helpful. This is the only communication we received in February, on May 4th. David, I just arrived at the emergency department at Santa Fe Press Hospital. It's a given I won't be able to telecommute for the rest of the day. Now that message doesn't tell you what hours he's claiming he worked. Ms. Burke just told you he claimed to have worked overtime that day, but it says he won't be able to telecommute for the rest of the day. So when he received that notice, Mr. Rich coded his time as half of a day of work and half of a day of FMLA. He also said, I'll keep you posted. We never heard from him again for the entire May absence. So
what time was the text? You say that it was coded for half a day of work and half a day of family medical leave act, right?
Roughly. I mean, I think it was 5 and 4 hours or something like that.
Okay.
But roughly, you're correct.
Yes.
I don't have the time in front of me.
Okay, but all right.
Okay.
That's fine.
But
what about February then?
Okay, going back to February. February 20th, I do not know what time, we have no knowledge of what time the appellant, the plaintiff, went to the hospital. We do know that he was only hospitalized on the 20th. When appellant's counsel says to you that the family spoke with the department, here's how it happened. The department reached out to his family. Nobody from the family called to provide notice. Instead, his brother, who is a co-defendant or a co-plaintiff in this case, is an employee of a different division working in a different office of the Department of Health. And Mr. Rich, the plaintiff's here's supervisor, found his phone number in that department and called him. And he said, yes, my brother's in the hospital. That's the only communication that the family made with the department. And although there's, you could ask, why didn't we call every day? Because we can't do that. That's the reason we have a policy that requires the employee to call and advise the department of their intent to seek and take leave.
Well, what happens if the employee is out of commission and he doesn't have any family and he's called once and said, I'm going into the hospital? Does he have to call the next day and the day after that, and the day after that?
Your Honor, the answer is no. He does not have to call. But he does have to call after he says, I'll keep you posted, and only wants FMLA entered for the day that he's left.
Now, that's in May you're talking about now.
Well, that's May.
I'm talking about February.
Well, what he's supposed to do is when he is completely incapacitated, I think that might give rise to unusual circumstances. But the testimony in this record, at his deposition, the plaintiff said he was able to use his cell phone. He could dial and call. His family was around him, and he didn't ask them to call in for him. So, we don't have a record where any kind of attempt was made at any time during these lengthy, 6-day, 9-day absences for him to make the effort to call in and advise us of what the status was. And that's just an admitted fact here. So, I would agree that theoretically, someone could establish a case of unusual circumstances if they were, unconscious, taken to the hospital. But that's not the circumstances of this case. He went to the emergency department. He had a cell phone that he could dial and use. Just didn't happen. So,
well, wait a minute. So he went to okay, we're talking about now the February event, right?
all right, yeah.
Okay, all right. So he goes to the hospital. He's in the emergency room. He texts saying that he's in the emergency room and he'll keep you advised. Keep them advised. Am I on the right incident now?
You are. I mean,
Okay.
the text message that's in May, of course. That message.
Oh, okay. See, that's what I'm
text
trying to.
message is May 4th, Your Honor.
Okay, so let's just walk through it to make sure I have it in my head. The
Okay.
incident in February. What did he go to the hospital in February?
He went to the hospital on February 20th. He didn't call anybody about any of that.
And that's the incident in where they reached out to his brother?
That the next day on Friday, he could go, remember, if we look at his time records, he's entering his time as though.
Okay, just help me. I want to just make sure I have the facts right. So
I'm
that's
sorry.
the incident where they reached out to his brother, right?
On the next day, the 21st.
On the next day.
The 21st.
Okay.
And
Okay, well, if he's in the hospital and he's incapacitated, what do you want from him? I mean, why would there be anything necessary in that situation?
Well, we would have expected him if he was capable of sending a text message and letting us know he was going into the hospital. That's what I would expect. But once we heard that, we coded him for AWOL because he hadn't called in on the 20th. He hadn't called in on the 21st, but he advised the brother, let him know he wasn't going to be at work the following week in the first 3 days. Those were coded FMLA. But
to Judge Kelly's point, I mean, if he had been in a car accident and therefore went into the hospital and was doped up, what he couldn't communicate. I mean, the fact that his brother tells you that he's in the hospital, that's good, that's nice. But I mean, in terms of him not complying with the policy, I mean, what would reasonably be expected of a person who either physically was impaired at that time, and I'm using the hypothetical of the car accident, physically impaired or impaired because of medicine or other things that render them incapable, I guess. And I'm not, passing judgment here. I'm just trying to understand in that situation, why would a policy require him to do anything in that moment?
Well, Your Honor, the hypothetical you pose, I would agree with you. I don't see how someone can be under an obligation to call in if they're completely and totally incapacitated. Those aren't the facts of this.
Okay, tell me. All right, and so let's narrow in now. Talking the February event, why is that different than the hypothetical? What is it about the February event that you say distinguishes it?
Because it is our understanding from the record that he had a cell phone and he was capable of dialing it. When you go to the emergency room,
capable of dialing it part, you can have in my hypothetical, you could have a cell phone sitting by your bed and you're on codeine too. And so, you couldn't dial it, or if you dialed it, it would be gibberish. So having a cell phone really doesn't answer the question, does it?
Well, it may. I just think that in these circumstances, he wasn't taken by ambulance. He drove himself to the emergency room. He was admitted through the emergency room. There's a lot of interaction and talking. He was with his partner. Somebody could have notified the department. If this happened late at night, then I would have expected somebody to call us in the morning. But
to Judge Kelly's point, there may not have been somebody. Not everybody has a family member. Not everybody has somebody who can call. And so if you're in a situation where, and to your point about the cell phone, I could have my cell phone, but I may not be capable of using it. And so let me just focus on, thank you for helping me on the facts, but let me focus on the regulation for a second. At least I was my understanding that the district court construed that as requiring a family member to call. And if that's so, the language says, you seem like you were quizzical about that. Is that not how you read what the district court's order said? That essentially the family member was obliged to call?
Well, I mean, one would expect the family member to call. I'm not sure the district court went that far. I don't know that was the district court's conclusion there. I think
Well, and I'm sorry to that. Let me just follow up briefly. Well, how do you read the regulation? I mean, the regulation uses the language may be given by the employee spokesperson. That seems to be permissive language, and I'm speaking about 825.303A. May be given by the spokesperson. Well, that's permissive language. That would seem to suggest that there was no obligation by the brother to call. There was no obligation by anybody to call. They may do it, but they weren't obliged to do it in that incapacity situation. What am I missing?
You're not missing anything except that all of these events, I believe, took place in the evening. There wouldn't have even been anybody to call. But what I'm suggesting is that the next day, somebody should have called. That's not
bingo. Let's freeze frame to the next day. Next day, the question is, would the regulation have required somebody to call the next day if you and I'm not saying you have to accept these facts, but if he was incapacitated on the next day, let's make that assumption. Would the regulations have required his brother to call?
Well, I agree with you. The regulation uses the word may, but I think one of the things that the regulation also says right before that language is that in most cases of even unusual circumstances, there's an opportunity to provide notice in some manner. And that's the assumption is that they can accomplish that. Now, that has never in the history of both February and May of 2020, nobody from around the family or friends of the plaintiff ever contacted.
And that's what I'm trying to understand. If you accept the premise that the regulation speaks in permissive terms,
yes,
then the question would be, why would they have to? I mean, it may be nice that they did it, but why would they have to? And note here, and you can tell me if I'm wrong, but what I'm juxtaposing is incapacity and family members who could or could not call. The question would be, if they didn't have to call, isn't it enough that he was just incapacitated?
Your Honor, yeah, I would say, if that were the hypothetically true, yes, I think you're correct.
And how do the facts differ from the hypothetical?
Your Honor, I'm out of time. Can I finish?
Please answer. I want to know.
Okay, all right. Well, first of all, the facts were, and they were established when Mr. Rich called his brother the next day, later in the day, on the 21st, that in fact he had been, I think he had either been, but he had knowledge that his brother was hospitalized. Now, at some point, it became apparent that, I mean, he only spent that night and the next day at the hospital. Then he was, I believe he was released. I'm not positive. But the point is this, at that point, the family knew that the employer was looking for him, wanted to know where he was and what was going on. And he admits he never, during any period in February, did he himself call in or did any member of his family call in. Now,
was he absent again in February?
Excuse me?
Was he absent again in February after he got out of the hospital?
Well, after he got out of the hospital, he was absent February 24th, 25th, 26th, and 27th, for part of the 27th. So the answer is yes. But Judge, just quickly on interference. Interference requires that the employer knows that this employee is seeking family medical leave. We never had any notice of that. So what you're asking is for us to find interference without any knowledge on the part of the employer. He was just simply absent. He wasn't there from the perspective of the employer.
Okay.
So until that phone call was made by us out of concern for his well-being, he hadn't invoked any right.
Okay.
So you're asking us to go back and insert an obligation to recognize FMLA when we had no knowledge that it was even in play. So I don't see how you can find interference on that record. Your Honor,
I'm going to have to hit the time button now. I appreciate your thoughts and thank you for your argument. Thank you. And in rebuttal, if you will give Ms. Berg 2.5. I meant 2.5 minutes, yes. Okay.
Thank you, Your Honor. So to clarify here, I think that the record's getting a little muddied here.
It is, and I want your help. Let's go walk through the two instances.
Okay, so Thursday, February 20th, 2020, Jeremy, there is no dispute that Jeremy worked physically in the office all day plus 15 minutes of overtime. Sometime during that evening, I want to say it was 8 p.m., but I could be wrong. He went to the hospital. There's nothing in the record to suggest he drove himself, like Ms. Maines said, but he went to the hospital. Some family member took him.
When did he get out of the hospital?
Pardon?
When did he get out of the hospital?
I believe he got out of the hospital sometime Sunday or Monday.
Was that the day, 21st or 22nd?
No, he was in the hospital for at least 3 days, Your Honor.
I'm sorry, speak up.
He was in the hospital for at least 3 days. And then he was incapacitated by his medical treatment. He was on a lot of opiate painkillers, a lot of codeine and all of that stuff. For that week, he recovered. They marked him properly.
So he was recuperating at home?
I believe so, Your Honor, yes.
Okay, and did he call anybody during that recuperation period?
There's nothing in the record to suggest one way or the other, but they recognized that he had FMLA designated leave for the Monday, Tuesday, and Wednesday of that week.
Okay, now in the May problem, didn't he say he didn't know his password had expired?
There was some issue before he went to the hospital, like the week before, that because he didn't have any job duties and wasn't receiving emails, he didn't notice when his password expired because the department, when he was at work, he had a giant monitor because the kidney damage was affecting his eye.
Was he working during that period of time at home?
Well, he was teleworking while his only job duty was to apply for disability retirement. That was what they tasked him with, even though that was not what he wanted.
Thank you.
So, and then in May, because he recognized that he was supposed to make sure he was giving notice, he did, in fact, give notice on his way to the hospital. Now, when you're on your way to the hospital suffering a medical emergency, you don't know if they're going to admit you, and you don't know what's going to happen next. You don't know what kind of drugs they're going to put you on. You don't know any of that stuff. So saying that you're going to stay in touch is his intent to stay in touch. It doesn't mean that his medical condition allowed him to do so. And that becomes the question of fact for the jury, is whether or not the May text gave sufficient notice that defendants should assume that he was invoking FMLA instead of calling him and telling him that he was going to be fired because he missed work and he could not retroactively designate his time.
All right. Thank you, counsel, for your arguments. Case is submitted.
Thank you, Your Honors.
thank you.
The next case this morning is 24-2179, Spinelli versus Coherus Biosciences. Counsel for Appellant, if you will make your appearance and proceed, please.
Good morning, Your Honor. May I please the court? My name is Vanessa Gennaro, and I'm here on behalf of the appellant, Mark Spinelli. He is also the plaintiff in this case. We filed this appeal as a result of a motion denying the complaint or dismissing the complaint under 12B6. We also filed a motion to consider and or amend the complaint under Rule 59E, and that was also denied. We're arguing today, Your Honor, we initially filed 5 counts in the initial complaint, and there was also an amended complaint because this case was removed from New Mexico State Court to the federal court. And so we filed an initial amended pleading, and then and we had 5 counts. And we appealed only on count 1 in part and count 4. Count 1 in part is under the New Mexico Human Rights Act, a violation of that act for disability discrimination and retaliation. And then also under count 4 would be for common law retaliation for both disability discrimination, retaliation, and as well as religious discrimination retaliation.
Ms. De Niro, could I interrupt you for a quick second here?
Yes.
I'm trying to get clear the procedural posture of this case and your understanding of it. It's a little bit of a head scratcher to me that the district court dismissed claims without prejudice, and we're here now, and so. And there is some language in your briefing, I think, that suggested below that you had some question as to whether this matter was final or not, or whether that was a final order. But so what is your perception of what the district court was doing and when it dismissed without prejudice? And connected to that is the fact that you filed a Rule 59E motion, which suggests that you did think it was final. So, I mean, was it final or was it not?
After doing substantial research on the matter, my understanding is that it was a final order because given the fact that this was a claim that was filed under the New Mexico Human Rights Act as well as the EEOC, there are statutory limitations on when the plaintiff can bring forward a complaint. And so upon dismissal of this case, Mr. Spinelli was prevented from bringing back the action because he would have been precluded by the statute of limitations due to the filing restraints with the New Mexico Human Rights Act. And so he would have been past that point. And there would have been no way to have, we did the research on it, and based on my understanding is that he would have been barred from making those claims. So our only recourse was to have an appeal. And
can I just stop you for a second?
Yes.
And so what I would see then as, and I appreciate your answer, what I would see then is that the court dismissed with prejudice and I mean, without prejudice. And our test really is that doesn't bar finality if you can construe the intent of the court to be actually to get the action out of court. I mean, to the action is done at that point, as opposed to it being sort of the setting the stage for further litigation. So when you filed the motion Rule 59E, if I'm understanding your position, and tell me if I'm wrong, when you filed the motion under Rule 59E, you were accepting the premise that was a final order, that the court's order dismissing the claims were final, and you were seeking then reconsideration of that final order. Is that right?
Yes, Your Honor.
Okay. And you also at that time, as part of your Rule 59E motion, it was a combined pleading, included that amendment request, right?
Yes.
Okay, thank you. That's helpful. Go ahead, please.
Thank you. We filed only under counts 1 and 4, specifically in part count 1 under the New Mexico Human Rights Act, disability and retaliation. The lower court, in its order to dismiss the case, concluded that Mr. Spinelli failed to articulate that he had limited that he had a disability because he failed to explained that he had major life activities that were limited by his disability. And in our briefing, we argued that he did sufficiently plead and that the court failed to consider the facts in favor of the plaintiff, given the totality of the circumstances and given the procedural law on point, essentially because in the amended complaint, Mr. Spinelli clearly demonstrated that his disability was due to a vaccine injury from previous years in 2015, and that vaccine injury resulted in permanent paralysis to the left side of his body, his torso, and his face, which there was some case law that certain disabilities can inherently demonstrate that there will be limitations on major life activities. And under the ADA and New Mexico Human Rights Act that follows the Americans with Disabilities Act, it's not trying to make it difficult for...
Excuse me, counsel, what was the major life activity that we're dealing with that you referred to in your complaint?
In the initial complaint, we specifically cite to the letter that was prepared by Mr. Spinelli's medical clinician, who stated that he was prevented from obtaining the COVID-19 vaccine because of prior injury from the vaccine. That
doesn't contact a major life activity, does it?
Well, it does, because he was unable to obtain a vaccine that is a part of a major life activity that because of his previous injury. It's just like being prevented from taking medications that could alleviate certain injury. And so that was not. There are specific acts that we did list in our response to the motion to dismiss to elaborate on this point. But
can I hit the pause button there? And there were statements and allegations of fact made in your response, right, to the motion to dismiss, and also in seeking amendment. I mean, in reconsideration and seeking amendment. But the court was limited to the facts in the complaint, right? I mean, in making its determination on both the 12B6 and on later when you sought the motion to reconsider. In other words, the fact that you allege facts that you thought could support your claim in response to the motion to dismiss would not really have any legal effect, would it?
I would argue that it would, because we have argued in our complaint, or in our motion, the response, but also the motion to reconsider, and as well in the briefing here in appellate court, that the paralysis to his body and to his face inherently, with common sense and any kind of experience and inference, the court should consider that is a major life activity. That's a substantial disability that's going to have impact on major life activity, even if I'm sorry, common sense. My common sense wouldn't necessarily lead me there. I mean, that's your obligation to plead that. And going back to Judge Kelly's point, I mean, the fact that there is an allegation regarding his condition still opens the door to what is the consequence of that. COVID-19, the vaccination is part of this mix, but the question is, the vaccination is not the life activity, is it? Well, it became a life activity unbeknownst to Mr. Spinelli when he took this job, that it actually was going to prevent him from working. And although that can be a fact that the court can consider, is whether or not an accommodation is required because the party would be prevented from working. There are other factors I just want to argue to hit this point, is that because we did provide additional facts and elaborated on the major life activities limited by the disability in our response and in our motion to reconsider, we argued that this would be a manifest injustice if the court didn't take the whole totality of the circumstances, all the information on the record into consideration with at least allowing for Mr. Spinelli to amend his pleading so that he can include those facts, because the court is now aware of him. And it would
and let me hit the pause button on that. I mean, the question is, why is the court obliged to do that? I mean, there was a 12B6 motion. The court ruled on that motion. It related to your complaint. When I read your motion to reconsider, at the end, when it had the amendment, there was one section, and essentially it incorporated through incorporation the arguments that had been made earlier. Well, why is it my job as a court to figure out what facts to fit into your second amended complaint, which you did not present a proposal? So I don't even know what facts you would want to configure your claim, right? I mean, why is that the court's obligation?
Because the court does not like to rule on technical violations of procedure, rather on the substance of the case. And because we did elaborate in our other filings that these major life activities were directly related to his prior vaccine injury, and it did cause paralysis, which made it very difficult for him to eat, to brush his teeth, to drive, to do basic living necessities. And what I know, Your Honor, you don't agree, but paralysis to your entire left side of the body and to the face, we argue that would inherently establish that major life activities are going to be affected and limited.
It really is not a question of whether I agree or disagree, Ms. DeNiro. It's a question of what was pled, and what was the position taken, because for a couple reasons. One, the COVID-19, avoiding the COVID-19 shot would have been predicated on having a disability. Am I following that correctly?
Correct. Yes.
Okay. Well, then the COVID-19 can't be the disability. I mean, it collapses those two things into one. I mean, you need the disability, and because you have the disability, you don't need to take the COVID-19 vaccination. The COVID-19 vaccination can't be the what allows you to have a disability, can it?
Your Honor, I would agree with you, although it did become a major life activity that was limited, a new limitation to his major life activities, because it prevented him from keeping this job that is a big part of his life. But importantly, we did elaborate on those facts to establish that there are limitations to his daily activities, and that was in the subsequent documents that were filed. And had we been allowed to,
that document wasn't your complaint. We're limited to the complaint. Motion to dismiss, and I guess I didn't understand your arguments in your brief, basically asking us now at this point to look to this other document that elaborated when the only real option for you is to once again amend your complaint, file a motion to amend your complaint, to add this element and explain what major life activity was impacted. Substantial impact, and that didn't happen. And the Rule 59 motion is too late. You can't just submit extra documents and expect the court, just because you want it to look outside the complaint. You can't look outside.
Your Honor, without allowing for Mr. Spinelli at the stage to not be able to amend his complaint, I'm sorry, at the motion to reconsider stage, would be a manifest injustice, because there are facts that do establish.
That's the Rule 15 standard, manifest injustice. You filed this under Rule 59.
And that's because there was no other option at that point. And
you had an option earlier. You had an option prior to that point.
In pleading the paralysis from the vaccine injury, the paralysis from our perspective was an inherent disability, and then also coupled with the evidentiary support of his doctor's note describing that disability, Your Honor. And so that was our understanding that was a known disability. And in the prior motion to dismiss filed by the plaintiff, they had not attacked that issue. They had attacked the religious discrimination allegation. And so that was not at issue at the point. We were under the understanding that the disability was already an accepted element or issue.
And let me ask you this, Ms. De Niro. I mean, even focusing on your amendment, the request for an amendment in the motion to reconsider, why even if the court were inclined to look at that, why was your showing for an amendment even sufficient? I mean, the local rule of New Mexico requires you to submit a proposed pleading if you're seeking an amendment. You didn't do that. You didn't file a separate motion seeking a second amended complaint. I mean, so and as I said, I looked at the section and all it says is look up there to find the stuff that would go into my second amended complaint. How is the court supposed to know what would be the content of your second amended complaint if you didn't tell it?
Based on the legal research, Your Honor, what we found was that in order for a motion to amend to even be considered, the motion to reconsider would first have to be established. And then
what I'm saying is you're showing for a motion to amend in any form. I mean, if for the court to say, look, I understand the research you're talking about, but if the court is going to say, okay, I'm going to now vacate this judgment so you can replead, well, it's going to have to know why it should do that, right? I mean, and what is it that you gave the court so it would know why it should do that?
We believe that we had sufficient arguments on the response to motion to dismiss and in the motion to reconsider so that the court could take in consideration all of those facts and circumstances in addition to the additional exhibits that were attached. And that would specifically with respect to the Spinelli's affidavit, setting forth explaining in detail what describes his major life activities that are limited by his disability. And that was our understanding. We did not know under the federal rules if we were permitted to file an attached amended complaint at that time.
Well, the rules of the District of New Mexico required you to do that. I mean, the local rules. And I'm sorry, I've taken you 2 minutes beyond your time. So I'm going to have to wrap it up. I'll give you
reply to that,
please.
Under Rule 59E, it doesn't, and the case law corresponding to that didn't make it clear whether or not an amended complaint could be attached. Under Rule 15, yes. And so that's where the uncertainty was at. We didn't want to violate yet another procedural rule by attaching a complaint.
Thank you. Counsel for Appellee, please proceed.
Good morning, Your Honors. May it please the court. My name is Ryan Carlson. I represent the Appellee Coherus Oncology, and I'm here today to ask Your Honors to affirm the district court's ruling dismissing the appellant's complaint. Now, this appeal asks whether the district court erred in dismissing Mr. Spinelli's amended complaint under Rule 12b-6 and denying his post-judgment motions for relief under Rule 59E. And
Mr. Carlson, is it your view as well, given the way this is played out, that the court's decision, albeit without prejudice, to deny the claims was a final order at that point?
That's correct, Your Honor. There was no indication that there would be any additional action. All the claims were out of court, and there was no specific request for leave in the judge's order to amend. So at that point, the more stringent standard under Rule 59E kicked in, which gives the court the most discretion in denying an amended complaint.
And not just amended complaint, but the point being that you accept the premise that when the court issued that order denying the claims on the motion to dismiss, that it put the plaintiff out of court, which is our language. And at that point, if they were going to get any relief at all, it was going to be through a 59E, right?
Yes, Your Honor.
Okay, thank you.
So, Your Honor, I would like to start with the disability discrimination claim. The district court properly held the amended complaint did not plausibly allege the definition of a disability because Mr. Spinelli did not identify any major life activity that was substantially limited by his medical condition. Now, Section 28 of the New Mexico Human Rights Act defines a disability not just as a physical or a mental impairment, but one that substantially limits one or more major life activities. And as this court already alluded to, the court is limited to reviewing only the allegations in the complaint. And the only allegations in plaintiff's amended complaint on this issue were contained in paragraphs 28 to 31, where Mr. Spinelli simply alleges that he had a permanent nerve condition from a prior vaccine reaction, and he received a doctor's advice that should he take the COVID-19 vaccine, that could put him at higher risk to exacerbate his existing health condition. There are no other factual allegations in the four corners of the amended complaint to show how his permanent nerve condition substantially limited any major life activity. And I'd like to direct the court's attention specifically to paragraph 64 of the amended complaint, which is page 33 of the appendix. In that paragraph, Mr. Spinelli specifically alleges, if, and I quote, if vaccination presents a real risk of the condition becoming serious and exacerbated, then plaintiff has a serious medical condition for purposes of the New Mexico Human Rights Act, end quote. So his own allegations in the amended complaint acknowledge he presently doesn't meet the definition of a disability. And I'd also like to direct the court to the Hughes versus Terminix case that we cited in our brief. That's in the Fifth Circuit. That is also in the COVID-19 context, where the court upheld the dismissal of a complaint under Rule 12b-6 because the plaintiff similarly based his disability on a potential future reaction by taking the COVID-19 vaccine to an existing health condition, and the court upheld the dismissal of the complaint. The ADA doesn't define disabilities under contingencies. So here, as the court correctly recognized, plaintiff did not plead any facts to show that a serious medical condition falls within the specific definition of a disability because he did not identify any major life activity limited by that condition. But even if this court were to assume that Mr. Spinelli did, in fact, plausibly allege the definition of a disability, there are still independent bases to dismiss the disability discrimination claim in count one. The first independent reason is that Mr. Spinelli did not meet the final required element of a disability discrimination claim, and that is to show that Coherus terminated him because of the disability as opposed to complying or failure to comply with Coherus's mandatory vaccination policy. So put simply on that point, whether Mr. Spinelli had a disability or whether he didn't, he would have been terminated for not complying with Coherus's mandatory vaccination policy. And that is precisely what the District Court of New Mexico ruled in the Duffy versus T-Mobile case that we cite in our papers. And I want to direct the court more recently to this court's decision in the Beresnack versus Arrow Electronics case. This was issued after the briefing in this case. Judge Moritz was presiding on the panel, and the 10th Circuit affirmed in that case dismissal of the ADA retaliation claim because the plaintiff's retaliation arose from his failure to comply with the company-wide COVID-19 vaccination policy.
And remind me, Mr. Carlson, did you submit a 28J letter on the Beresnack case or not?
We did not, Your Honor.
And just so that we have a complete record, if you would, that would be helpful.
Sure, Your Honor, and that is case number 24-1394, August 27, 2025.
Okay.
So here, as in the Beresnack and the Duffy case, the missing element is causation. The complaint establishes that the termination stemmed from non-compliance with a company-wide policy, not because of his disability. And it's also significant that there's no allegations in the amended complaint that Coherus had any knowledge whatsoever of his medical condition at any time prior to implementing the COVID-19 vaccination policy. There's also allegations in the amended complaint where Mr. Spinelli specifically alleges that other employees who were not disabled and didn't take the vaccine were likewise terminated. And that's in paragraphs 18 and 41 of the amended complaint. So even if this court were to assume that Mr. Spinelli did establish that threshold test of a disability, it still fails to establish the required causal link. And the second independent basis for dismissal of count one, the disability discrimination claim, is that Mr. Spinelli did not show that he is a qualified individual with a disability because he was someone who could perform the essential functions of in-person work with or without a reasonable accommodation. And the amended complaint itself establishes he couldn't. The amended complaint acknowledges that Coherus had a policy to require at least 60% of interactions with customers to be in person. Mr. Spinelli refused to comply with that requirement. And because of that, he refused to comply with the policy requiring in-person attendance. And I also want to point out,
I thought almost all of Mr. Spinelli's accounts, he was managing remotely. In other words, there were only two, is my recollection, that he wasn't managing remotely. And so how does that policy square with that fact? I mean, this was right up until the end, it's my understanding. I know that was the rule, the situation in COVID, understandably so, but even after COVID, wasn't that what he was doing?
Your Honor, even accepting that allegation as true, I know that's in his complaint, but it is irrelevant for purposes of Coherus's business judgment to restore those essential functions and begin the phase-in return. Employers are allowed to begin to prepare to return to the office, and that is why it instituted a phase to return to work policy. And I want to direct the court.
Could you briefly address the public policy, the dismissal of the state law claim, the public policy claim? No, in the briefing, the appellant discusses the fact that there's under the NMHRA, the New Mexico Human Rights Act, has both contains within it a right to be free from unlawful discrimination and retaliation, as well as a remedy beyond just administrative and court proceedings. And the Supreme Court of New Mexico has held that includes a remedy for suing for common law claims, retaliation type claims such as this one. So why wasn't that sufficient to state a public policy?
Well, Your Honor, first, his public policy retaliation claim fails just like his statutory retaliation claim because there's no nexus. There's no causation between the protected activity, whether that is, let's just assume under the New Mexico Human Rights Act, or whether it was due to his other source of public policy in protecting his bodily integrity from taking the vaccine. No matter how you slice it under either theory, it fails for lack of causation. And again, I would direct the court to the Bereznak versus Arrow Electronic case, as well as a host of other courts around the country, the Szymakowski Second Circuit case, as well as the Jorgensen Fourth Circuit case, and the West Ninth Circuit case, who all say when the protected activity comes after the announcement of the COVID-19 vaccination policy, there simply can't be any retaliation at the 12B6 stage. But to answer your other question, Your Honor, he didn't argue the New Mexico Human Rights Act was the source of public policy. That's acknowledged in page 35 of his own affirmative brief, but it simply fails for those same reason that the other statutory claims fail.
The district court dismissed it just because he didn't state a public policy violation, essentially.
And correct, Your Honor.
Beyond that, but you're saying we could look beyond that and find causation.
Yes, Your Honor, you could look beyond that under this court's de novo review for lack of causation. But the judge's point on that issue was also correct in that refusing to take the vaccine is a personal choice. It doesn't implicate the public. Coherus simply told Mr. Spinelli, like all other at-will employees, this is a new condition of your employment to continue working here. You have the option. If you can't comply with this requirement, you're free to work elsewhere. That's a personal choice. It's not anything that implicates the public policy. And with my remaining time, Your Honors, I'd like to address the post-judgment motions. This court acted well within its discretion in first denying Mr. Spinelli's Rule 59E request to reopen the case. As this court has repeatedly recognized, reversal under Rule 59 is an extraordinary remedy. It's limited to instances where there is clear error or whether the district court exceeded bounds of all permissible choice. And Rule 59E is not a chance to re-argue matters already before the district court. That's exactly what Mr. Spinelli attempted to do, and he couldn't satisfy either of the three criteria to reopen the case under Rule 59E. He presented no intervening change of law. He didn't show any clear error, and he didn't show any new evidence that was previously unavailable at the time he first filed his complaint or his amended complaint. So under this court's deferential standard, there's no basis to disturb the district court's decision to deny the Rule 59 motion. And the district court also properly denied Mr. Spinelli's request to amend under Rule 59E. I know there was discussion with Appellant's argument on this issue, but I think we're all in agreement that Rule 59E is the standard because Mr. Spinelli did not make any request to amend the complaint at any time prior to dismissal other than his already amended complaint that he did as of right under Rule 15. And because we're now living with that standard, Rule 59E, the district court is entitled to much broader discretion. Again, Mr. Spinelli must first reopen the case and meet one of those three criteria. He did not, and by not clearing that hurdle, this court not even decide whether or not the district court's decision in denying leave was correct. But even if, again, we do consider the district court's decision to deny leave under the traditional de novo analysis in accepting as true the submission that he did in support of that motion, accepting everything as true, he still can't plausibly allege a disability under the New Mexico Human Rights Act. He still can't plausibly allege a claim of retaliation under the New Mexico Human Rights Act or at common law. So for those reasons, we respectfully ask that the court affirm the dismissal of Mr. Spinelli's amended complaint. And I can finish my argument unless the court has any other questions.
I don't have any questions.
No
Colleagues? Okay, hearing none. The
Thank you, Your
case
Honor.
is submitted. Thank you for your arguments.
Thank you, Your Honor.
The next case this morning, and before we get into that, I would just say that we're going to take for all listening, a small 10-minute break after this argument. And with that housekeeping note, let's begin. It's 24-4073, United States versus, I'm sure butcher this, but Aguayo-Montes. And with that, counsel for appellant, if you'd make your appearance and proceed, please.
Good morning. Can you hear me, judges?
Yes.
Wonderful. This is Benji McMurray here on Mr. Aguayo. I've been a defense attorney for a lot of years, and when I advise my clients about taking a plea agreement, I often tell them that my most important function at that moment is to help them assess the risks of different possibilities. Usually what we're talking about is the risk of a conviction after going to trial. I don't think anybody could reasonably conclude that I would discharge my duty as a criminal defense attorney by telling my client, if you go to trial, you might be convicted. That would be unimaginable. And the suggestion by the government that a defendant or that a defense attorney discharges his constitutional responsibilities under Padilla by just saying that a particular risk exists really misunderstands completely the entire process of what defense attorneys do. Now, in this case, what we see is a defense attorney who violated Padilla in two significant ways. Number one, the defense attorney affirmatively misrepresented the immigration consequences of this conviction.
How did he do that? How did he do that? He told them that there may be immigration issues.
So if he had stopped there and the government was right on the law, then we wouldn't have a problem. But he didn't stop there, and the government's wrong on the law. But in terms of not stopping there, he didn't just say you may be deported. What he actually said was, you don't have to worry about this until you get to prison. And that was flat out wrong. I don't think there is any circuit, any standard where that advice would be sustainable. Once Mr. Aguayo had been convicted and found himself in prison, there was no immigration attorney anywhere who could resolve the problem that his conviction made him automatically deportable. So that's the first problem, is that we have an affirmative misstatement of the law, which even the concurrence of Padilla would countenance as a Sixth Amendment error. Now, second...
So let me clarify that you're basically suggesting that we don't even need Padilla. We don't need to analyze whether Padilla, what the perfect language is, whether it's, with certainty he's going to be deported, or whether it's subject to deportation, because this was affirmative misadvice that even pre-Padilla would have been actioned.
Yes, I agree with that, Your Honor, that in fact, the affirmative misstatement here would have been reversible, or would have been deemed a violation even before Padilla. I don't think there was any question before Padilla. In fact, the Solicitor General conceded the point, the concurrence agreed with the point that affirmative misadvice was constitutionally problematic. Now, with respect... Yes, Your Honor.
Let me understand one point, though, Mr. McMurray. Let's assume you end up prevailing. Isn't it important for the prejudice aspect that we know the scope of the deficient performance? In other words, there's one thing, the affirmative misstatement as it relates to, you don't have to worry about this. But I mean, if the statement that you might be deported is in itself another affirmative misstatement, then it's important for us to make a determination as to whether it is or it isn't, right?
I'm not sure I understand the question.
All right, then let me rephrase it. Let's assuming the wonderful world in which you win, okay? And if you win, and then what the question we're talking about is, how was he harmed? In other words, would it have been such that he would have been harmed by this advice that he received? We would want to know what is the scope of the misconduct, if you can use that word, or deficient performance, in order to measure the extent of the harm.
Well, Judge, and I apologize if I'm missing your point, but it seems to me that your question may be conflating a little bit the first prong and the second prong. I think
I'm trying to do exactly the opposite. Judge Moritz talked about the notion of, do we have to get into the nuance of what Padilla commands? What is the nature of the counseling that needs to be provided? And what I'm trying to suggest is perhaps we have to do it a little bit, because we have to know what is it that was violated? What ran counter to Padilla here, if anything?
So let me speak to that, and I do think it's an important question, and in fact I think this is really the second big piece of this, because in addition to identifying an affirmative misstatement, I do think that counsel fell short of his affirmative obligations under Padilla, and so. Let's talk for a minute. The government says that effective counsel can discharge his duties by simply advising the defendant, you may be deported. All right. And the government, I think, in making this argument, really cherry picks one phrase of Padilla, where they state the holding at the end of the case. And the government construes this statement of the holding in a binary fashion. Either you have to advise them whether a risk exists, yes or no, on or off, black and white. And so that's the government's argument. And I think when you read Padilla in its context, that myopic focus on that last claim really is unsustainable. So let me just point you to a couple parts in Padilla that I think are really useful. First of all, you've got at the very beginning of the decision, you have language, let's see, that talks about that the council has the duty to advise about an automatic deportation. On page 1478 of the Supreme Court reporter, constitutionally competent counsel would have advised defendant that his conviction for drug distribution made him subject to automatic deportation. This is the risk that Padilla is talking about, not just the mere possibility of removal. I suspect probably every non-citizen defendant walks into court that very first day knowing there's a risk. They probably don't even need an attorney to tell them there's a risk. Now, in many cases they do, but what they need is an attorney who will tell them, who will quantify that risk. Now, so how much does an attorney need to say about that?
The Supreme Court has never said that you have to quantify and go into great explanation about the probabilities. You must advise him that he may be deported.
So
now the rest of it's just generous.
Well, I again, Your Honor, I think that trends towards this myopic reading of Padilla because the Supreme Court has given us some guidance. And the Supreme Court, to be sure, does say there are situations where the consequences are too complex to pin down, but the Supreme Court identifies at least one category of cases where it's not so complex. And so, in fact, this is on page 14.
Wouldn't you have to show or at least argue that but for the lack of appropriate advice, the plea would not have been taken? And if it wasn't taken, the conviction is open?
Yes, Your Honor, but that goes to prong 2 of Strickland. That goes to prejudice. That's a factual question. There is no finding.
That's what Chief Judge was trying to get at. Where is the prejudice?
Well, you're talking the judge in this case. I mean, the record.
Judge Holmes was trying to get you to answer that question.
Well, so I think the prejudice. So there are two parts, right? The constitutionally deficient advice. And we can talk about the ways in which this was constitutionally deficient. And we can try and quantify or qualitatively describe what competent advice should look like. And I do have some comments on that still to make. But with respect to prejudice, the prejudice prong is simply had defense counsel effectively advised the defendant, would the outcome have been different? Would he have taken the plea agreement? And on that second prong, that is a highly factual determination. The district court did not reach that question. And so a remand would be necessary to decide, had the defendant known the consequences, would he actually have rejected this plea agreement?
And Mr. McMurray, let's go back to the deficient performance. And I want to tease out something from your colloquy with Judge Kelly. It seemed to me, the language that I looked at in Padilla that sticks out to me is where the court said, when the deportation consequence is truly clear, as it was in this case, the duty to correct advice is equally clear. Now, it seems to me that one could posit, and I want to get your reaction to this, one could posit that a counsel is not required to do a probabilistic analysis, and I think that's what Judge Kelly referred to, but they are required to tell you things that are straightforward and clear, like this makes you deportable, full stop, and you're presumed to be deported under this, because I think that language appears in Padilla as well. And so, I mean, it seems to me there are two different things here. Do you accept that the notion that if it's clear that number one, you're deportable, and number two, it's presumed you'll be deported, that those things are clear on the face of the statute?
Yes, I agree with that. I think that's exactly what Padilla says.
And let me hit the pause button.
All right, go ahead.
That's what Padilla says. Would you accept also that you would not necessarily be in a game where you had to give odds of whether you ultimately would be deported. That was Judge Kelly's reference to probabilistic reasoning.
See.
It would seem to me that that is not required by Padilla, but I want to hear your response to it.
So I think that when it comes to this probabilistic inquiry, I do think that's a little bit more complicated. My clients ask me all the time, what are the chances I'm going to get convicted? What are the chances I'm going to get a sentence of X, Y, or Z? And I often oblige them by giving them a number. 60% chance you get a 10-year sentence, 20% chance you win at trial, all right? You know, whatever it is. There is nothing scientific about those odds. And I can't imagine a scenario where a defense attorney who obliged the defendant by giving odds, you know, was deemed to be ineffective because he obliged them in that way. I mean, this
well,
is
but what I'm saying is, would that defense counsel be required to give the grace that you did in that situation?
No, I don't.
Padilla wouldn't require that, right?
And I don't think Padilla requires that kind of specificity with respect to the odds. But what Padilla does require is that what's knowable, you have to tell them.
All right.
And in other cases, in a different case, we could argue about what's knowable. But this case is indistinguishable from Padilla. Going back again to 1478, constitutionally competent counsel would have advised the defendant that his conviction for drug distribution made him subject to automatic deportation. That's the affirmative duty that Padilla articulates. This, like Padilla, was a drug distribution conviction. There is no meaningful distinction. This case is controlled by Padilla. I'd like to
let me
all right, go ahead.
I think Judge Moritz has something.
Just a quick question. I wanted to, I think you may have just answered it by that language for Padilla about being subject to automatic deportation. Your brief uses different language, sometimes the Ninth Circuit's language about certainty, and they're all very close, but would you say that had that been the language used here, subject to automatic deportation or presumptive deportation, that it wouldn't have required the word certainty, which to me seems to get more into the probabilistic.
I do agree with that, Judge, and I will hold that out as a deficiency in my briefing. There are a lot of ways that people have gotten at this, and the Ninth Circuit has gotten at it one way. I will note that the Eighth Circuit in Ramirez-Jimenez, where the government focuses on, that's not an ag felony case. That's a crime involving moral turpitude. That's tremendously complex. Ag felony, not complex.
And let me tease out from Judge Moritz's point. It seems that Padilla regrettably has different uses of language in this, but it seems to me that it wouldn't the word presumptively deportable matter more, because I mean, he could have some discretionary relief. We don't know, right? What we know is that the statute makes him deportable, and it can be presumed that he is deported, and Padilla uses the language presumptively deportable, right?
Let's see. I don't remember if Padilla uses the word.
It uses. I'll find it. It uses the word. Yeah. Okay. Go ahead, please.
Well, I guess here's the thing. I think that
presumptively, it says deportation was presumptively mandatory.
Yes, thank you. I would feel very comfortable using those words. I think the language of Padilla requires reversal in this case. Let me just say very quickly, if I could, as a concluding thought, I believe that the standard of Ramirez-Jimenez is supportable by Padilla, and I believe that Judge Holmes, that you could be right, and probably are right, that if it's clear that defenses to removal exist, that competent counsel should at least acknowledge those, and as in this case,
no, I wasn't positing that. No,
okay.
No.
Okay.
All I was saying is presumptively, presumptively mandatory, which means that you may be able to get out of it. That's not my business to know how you could get out of it. No, I wasn't going there.
I think that construing Padilla in that way would not be incorrect.
Let me ask you a housekeeping question, and opposing counsel, I'll give you sufficient time. Let me ask you a housekeeping question. There is some language about Mr. Kramer. The idea was that Mr. Kramer provided, he met with Aguayo to discuss the plea agreement. And did he do more than just read what the plea agreement said about what the condition would be for his possible deportation? In other words, the language in the plea agreement, did he give a separate advisement apart from that?
That would be a great question at an evidentiary hearing. The information that I know is largely described in the petition. And of course in the petition it's in a summary fashion of a conversation, but Mr. Aguayo says, I told him I didn't want to be deported. That was my biggest concern.
But the petition speaks as if what he did is he came in and said, I want you to know this is what we are agreeing to, and read the language about you may be deported.
Yes, my understanding is that there was zero explanation of what that meant, and that such was not needed because that could be taken up with an immigration attorney once he was in prison.
Understand. Okay, thank you, counsel. We'll hear from the government now.
Good morning, Your Honors. Briggs Matheson for the United States. Your Honors, I'd like to start with the question that you posed to my friend about whether there is any prejudice shown in this case, because I do think that is, as Strickland posited, the more straightforward basis to affirm the district court's denial of Mr. Aguayo's 2255 petition. And that analysis begins from the strong presumption that what Mr. Aguayo told the district court below under oath in writing and orally was true. And that's that he wanted to plead guilty because he was guilty, and that he wanted to plead guilty knowing that that could lead to his ultimate removal from the United States. And as this court explained in Hurd versus Addison, in Dominguez, most recently in United States versus Kern, the inquiry at that point focuses on the objective evidence, the factual circumstances surrounding the plea. And it asked whether it would have been objectively rational for Mr. Aguayo to have rejected what was ultimately a very favorable plea agreement. The plea agreement contained a stipulated sentence that was about half of the low end of Mr. Aguayo's.
Well, you're going into prejudice now. We should focus first on the performance issue. And I guess I don't understand why the fact that he told the court that he understood the plea when it said, and the plea used this exact language, you may be at risk for deportation. And he says, I asked my counsel, what does that mean? That's very important to me. What does that mean? And my counsel said, I don't really know. I'm not an immigration lawyer, but hey, don't worry about that until you're in prison, and then you can talk to an immigration lawyer. That's what his counsel explained, that line in that he was going to be agreeing to meant. And so he said, okay, that's his testimony, I guess. I said, okay, I can agree to that. That's what I'm going to do. He was given potentially affirmative misadvice by if this was affirmative misadvice, by his counsel that led him to say to the court, okay, yes, I understand what risk of deportation means. So aren't we really, isn't that really kind of a fact question that, and as opposed to anything that we can talk about yet, what the court might have, what impact his agreement to the court meant. You see what I'm saying? We're looking at what counsel told him and whether that might have confused him.
I think I understand the court's question. Let me take it in two parts. The last part of Your Honor's question, what can we take from his statement at the plea hearing? What can we take from his signature?
And that was your focus. That's your focus. But my focus is, what did his attorney tell him about that very line in the plea?
Understood, Your Honor. Just briefly, the point that I was making is just the departure point for the prejudice analysis is the presumption that what Mr. Aguayo previously told the court was true. Now, it goes on from there, and I'm sure we'll get into that. But to address the other part of your question, the scope of counsel's duty under Strickland, under Padilla. I want to address first my friend's suggestion that what Padilla really requires is more than advising the client whether his guilty plea carries a risk of deportation. And that's the language that Padilla articulated in its holding. And I agree with my friend that the context for that holding in Padilla is important. I just happen to think it points away from the type of rule that he is proposing this court should adopt. And I would point the court in particular to the Second Circuit, the en banc Second Circuit's opinion last year in the Farhane case that's cited in the government's brief. And in that case, the Second Circuit cataloged the majority opinion in Padilla, and it noted that on 5 or 6 different occasions throughout the opinion, Padilla emphasized that it was talking about the risk of deportation. It wasn't speaking in terms of ultimate removal from the United States. It talks about eligibility for deportation, the possibility of deportation. That was the risk that Padilla was concerned needed to be conveyed to the client in that case. And Chief Judge Holmes, I do want to address the specific language that you cited from Padilla about the clear consequence and the need for the advice to be equally clear. That comes at page 369 of Padilla, and it follows the court's articulation of what the succinct, clear, and explicit consequence of Mr. Padilla's conviction was. And notably, the majority does not say that the clear consequence of Mr. Padilla's conviction is that he ultimately will be deported. And it doesn't say that his counsel erred because she failed to inform him that he would be deported.
Well, the clear consequence was definitely more than that you have a risk of deportation. He was presumptively mandatorily deportable. And if you look at the statute, there's no risk. I mean, that's the way it is, right?
Well, two responses to that, Your Honor. The statute uses the word deportable. The majority in Padilla at page 368, again, when it's talking about what the succinct, clear, and explicit consequence of his guilty plea was, they describe it as his eligibility for deportation.
He didn't this lawyer told him you had a risk of deportation. He didn't even tell him you were deportable. Because if he had told him that, what that would have told him is his DACA status was done. And then the question was whether he was actually going to leave the country. That he didn't even tell him that. He just said you have a risk of deportation. Didn't he?
To be clear, Your Honor, I think what the record shows, and at this point, all we have are the allegations in the 2255 motion. What Mr. Aguayo alleges is that he and his counsel read paragraph 2B of the plea agreement, which says in no uncertain terms, if you are not a United States citizen, you may be removed from the United States. That, I think, is fairly straightforward as the word deportable in the statute, which I think
May is permissive. That doesn't say deportable means you enter into a different status. If you're in a DACA status, you're not deportable. If he had just said that, even though I don't think that Padilla necessarily meant that enough, but if he had said that would at least put him in a different situation. And what I note, Mr. Matheson, is if you look at what Judge Alito says when he joins, he even says that what was required is what this law requires in a succinct and straightforward fashion. What does this statute require in a succinct and clear fashion? It says you're deportable, right?
It does, Your Honor, but I read Justice Alito's concurrence to be responding to what he described as a, quote, vague halfway holding in the majority opinion that is susceptible to these types of interpretations that the Ninth Circuit and the Fourth Circuit have adopted, but the Eighth Circuit has rejected, and that the Second Circuit in Farhane, at the very least, appears to be resistant towards that kind of a safe harbor words type of requirement. Again.
So he's complaining about it, but he's acknowledging that's what they're holding. He doesn't like it, but that's what he says they're holding, right?
I think he is expressing his concern with the way the holding could be misinterpreted, again, describing it as vague and a half measure, a halfway type of holding. But what Padilla actually says, the majority does not go so far. It says, we now hold that counsel must inform her client whether his guilty plea carries a risk of deportation. And that was the Strickland prong one error in Padilla. And again, as my friend points out, we don't have to speculate about how the Padilla majority would have addressed Mr. Aguayo's conviction. It's the same class of aggravated felony. And Padilla does not say that Mr. Padilla's counsel failed to meet the standard under Strickland and was objectively unreasonable because she failed to inform her client that it was virtually certain he was going to be deported. or to use
I don't
the
even
word
want to use
such
the virtually certain word. Let me ask two questions. Do you accept the premise that the clear, unambiguous language of, 1227 would be that if you get a controlled substances conviction, you are subject to deportation? Not may, not risk, you're subject to deportation.
Respectfully, Your Honor, I would say that the statute uses the word deportable. And insofar as
all right, let's go with the word deportable. Do you accept the premise the statute says you're deportable if you have that conviction?
Yes, you are subject to deportation.
Well, is there a distinction between risk of deportation and you're deportable?
I think that under Padilla, the concern under the Sixth Amendment is that risk sufficiently conveys to the client the possibility of removal from this country.
But if Padilla calls for you to, that passage that I alluded to before basically was designed to respond, I think, to the dissent and saying, look, we're not requiring you to do anything complicated here. Immigration law is complicated. But if something on its face says A, and counsel can easily see A, then counsel has to tell their client A. And if, as I understand you to accept the premise that this statute says if you get convicted of a controlled substance offense, you're deportable, why would the obligation under Padilla not to say not that you have a risk of deportation, not that you may be deported, but you're deportable? Why would that obligation not exist?
Two responses to that, Your Honor. The first is that if Padilla wanted to impose a requirement that counsel must parrot the language of the statute and use the word deportable, that is the only way to satisfy the Sixth Amendment and to discharge his or her duty under the Strickland prong 1. Padilla would have said that. Instead, when it says what it held, we now hold that counsel must inform her client whether his guilty plea carries a risk of deportation. They wouldn't have said that. The second point, Your Honor, is that it makes sense that Padilla would draw the line where it did. Ultimately, Padilla is an application of Strickland's performance prong. And under the court's Sixth Amendment jurisprudence, the question is not whether counsel used specific language from the statute. It's not whether counsel gave perfect advice or even best practices. The touchstone is always whether counsel's advice was objectively unreasonable. And I think under the circumstances presented here, where counsel reviewed the plain language of paragraph 2B of the plea agreement, which states, if you are not a United States citizen, you may be removed from the United States. The risk, whether the guilty plea carried a risk of deportation, that information was conveyed to the client.
No,
it
wasn't.
No, go ahead.
It wasn't. It was not conveyed. That was according to Mr. Aguayo-Montes. He said, what does that mean? What does that sentence mean that is in my plea agreement? And what is in the record is that his counsel told him, I don't know. I'm not an immigration attorney. You'll have to wait till you get to prison and then you can get your immigration attorney. That is not saying, oh, that just means what it says. You're at risk for deportation. It isn't even that much. It's misadvice. And what is that competent counsel to say, yeah, I don't really know what that means. You'll have to wait. That is misadvice and misleading. And I just don't know where the record confirms what you're saying. The counsel said it means what it says, essentially.
Your Honor,
he did something worse than that.
Your Honor, I agree that if all that had happened below is Mr. Aguayo had gone to his attorney and said, what are the immigration consequences of my conviction here? And counsel had said, I don't know, don't worry about it. That would be a stronger case that counsel failed to convey the information that Padilla requires, which is whether his guilty plea carries a risk of deportation. Now, I understand the court's point. I do want to emphasize with my limited time, however, that even if counsel's advice fell below Strickland prong 1, Mr. Aguayo cannot satisfy prejudice in this case. As this court has said time and again, Chief Judge Holmes, as you explained in Dominguez, Judge Moritz, as you explained in the Rippey case, both are cited in the government's brief, the focus remains on the factual circumstances surrounding the plea and asks whether there's anything in the record that substantiates the appellant's or the 2255 movement's after the fact allegations about what he would have done, what he cared about, and why he would have insisted on going to trial.
You're absolutely right, but why, and I'm sorry to cut you off, but you're absolutely right, but why do we do that here? I mean, if there is deficient in performance, the district court did not reach the prejudice prong, and so why would that be an undertaking we would even attempt here?
Because the record is sufficient to make that determination, and as this court has done time and again, it can decide the prejudice prong without addressing performance, and even if there's no evidentiary hearing below. And I would cite the Gilchrist case, Saucedo, Avalos, and the Headley case that are all cited in the government's brief. More to the point, Your Honor, the record in terms of what can substantiate the defendant's after-the-fact allegations is not going to change as a result of remanding or any sort.
Why wouldn't it? Didn't they file? Did anybody get the Kramer file, Mr. Kramer's file?
It was not available, Your Honor.
And it's not available. Well, why couldn't it be available below?
Your Honor, I can represent to the court that we're unaware if it exists. Setting that aside, however, the more important point, I think, is that the inquiry is largely objective. It looks at the objective evidence, and that is what is not going to change. The question, the type of evidence that is lacking in Mr. Aguayo's case, I think, is best shown by comparing it to the types of cases where that evidence was present. Let me direct the court first to the Rodriguez-Vega case, the Ninth Circuit case that my friend relies on under Strickland Prong 1. In that case, the court noted that the defendant had previously rejected a plea offer that contained a stipulated removal provision, a stipulated removal provision. That was evidence, the court noted, that substantiated what Rodriguez-Vega was saying after the fact about what he cared about. There's nothing like that here. Or, for example, in Lee versus United States, as we pointed out in the brief, there the plea colloquy reinforced or supported what Mr. Lee was saying after the fact. And as this court pointed out in United States versus Reed, the most important evidence in making this prejudice inquiry is the strength of the government's case. And in this case, Mr. Aguayo doesn't allege that he was innocent, doesn't identify any plausible or viable defense to his charges, and doesn't even allege that there was any infirmity or weakness in the government's proof against him. And so what is worrisome about this, Mr. Matheson, is that the district court didn't tease any of this out. I mean, what we'd be doing is being called upon to do this on appeal, and having to be, we would be betting that there wouldn't be anything else found below. I agree with you that it's an objective standard. I mean, well, the law is the law. It is an objective standard. But how are we situated to be able to know? I mean, I don't know what could be found below in a hearing. Let me give the court two responses. I see I'm out of time. The first is that this court has addressed prejudice under these circumstances before in the Gomez-Lugo case that's cited in the government's brief. That was actually a direct appeal of an ineffective assistance claim based on a Padilla violation. This court determined that the record was sufficient to deny the claim on prejudice grounds. Secondly, and I think more importantly, again, the two most important sources of evidence that this court looks to, contemporaneous with the plea. What happened at the plea colloquy, that's what Lee versus United States teaches, and the strength of the government's case. That's what Dominguez and Rippey and Hurd versus Addison require. Those two sources of evidence are not going to change on a remand for an evidentiary hearing, because we know what happened at the plea colloquy, and we know that Mr. Aguayo does not even allege any weakness in the government's case.
Let me interrupt you, because what happened at the plea colloquy here is very instrumental in terms of what happened is he agreed to this plea agreement where he had been misinformed about what the meaning of it was. So, I mean, I don't know that, any court looking at this now could necessarily rely on that plea agreement. And I guess what you're not taking into account here is what the court said in Lee. And I don't think that was restricted to the facts of Lee, which is there are many cases like this where a defendant facing deportation would much rather reject any plea agreement in favor of a Hail Mary because they want to stay here. This was a DACA recipient. Been here since he was a child, young child. And we don't know what the district court might do with these facts, but I don't quite understand why we wouldn't give it back to the district court.
Because, Your Honor, I think that gets the analysis that Lee requires backwards, which is the question is, what does the plea colloquy show to substantiate the allegations. And in Lee, when the district judge asked Mr. Lee, how do the immigration consequences of your conviction, or how does that affect your decision to plead guilty today? Mr. Lee said, I don't understand. And it was only after his counsel came over and assured him this is just a boilerplate type of warning that he was willing to plead guilty. And so the court said that is the type of evidence that supports the after the fact assertions and leaves room for doubting his plea and his testimony under oath that he wanted to plead guilty, notwithstanding or with an understanding of the immigration consequences. And here, looking at the plea colloquy, there's an absence of substantiation. There's nothing in there like the exchange in Lee, or like the objective evidence in Rodriguez-Vega, or even in the Fourth Circuit case in Swaby, where the defendant at least alleged, I would have contested the estimated loss amount for my counterfeiting conviction if I had different advice of counsel about the immigration consequences. And the court said that's the type of argument that at least needs to be made, and it would be objectively rational for a defendant to challenge that type of conviction on that particular element. Mr. Aguayo does not even allege that. And so I don't think that there's any reason to remand for something that he's not even asserting.
Thank you, counsel.
Thank you, Your Honors.
Mr. McMurray, I was going to end this, but since Mr. Matheson, we did it, my fault, but since he's gone over, why don't we go for a minute and a half if you want it. You don't need to take it, but if you want to take it.
Well, certainly if the court has any questions, I just maybe, because you've asked about it a lot, Judge Holmes, one of the ironies that I see in the government's argument today is that it seems to be the government that is actually pushing us towards a quantitative risk assessment. Because what the government, I think, has essentially conceded the rule of Padilla, that the conviction here rendered him deportable. And they want to say, well, it doesn't really matter because there were these defenses that could have been available. So we can't really say that it was automatic. I don't think the court needs to go there. I think the court could. The Ninth Circuit did. I expect more of defense attorneys, but I think under Padilla, it's clear that I think this case is indistinguishable from Padilla. This is a drug trafficking conviction, just like Padilla. And Padilla tells us the duty of counsel. When there's a drug trafficking conviction, you have to tell them that deportation is automatic. I think that, again, looking at the Eighth Circuit case, I think the court can meaningfully distinguish between aggravated felony cases and crimes involving moral turpitude. I'm not in a position to hazard a guess on CIMTs, but ag felonies, it's a list. It takes some work, but that is exactly what the lawyers are expected to do. On prejudice, I think you've got the point. There are no factual findings here. What
is the story on the Kramer file? What's your view on that? Is it obtainable?
So yes, we have it. We just haven't had the chance to get to discovery. And so we're happy to produce it if we get to that point, but I've got it. And, he was alive when we filed this, but there are many issues. There's credibility determinations. There are factual determinations. There may be more to come out about what Kramer actually said or didn't do. His files may have something, so it's not a done deal. What Lee importantly tells us that this court can't do is defined as a matter of law, which is what the government essentially wants you to do. You can't find as a matter of law that the petitioner's assertion that he would not have gone to trial had he been correctly advised. You can't find as a matter of law that that's an irrational position and therefore unacceptable. We have to have an evidentiary hearing on the second prong.
All right, case is submitted. Thank you for your fine arguments, counsel. As I indicated, it is 55 after the hour, and we'll be back 10 minutes from now. Thank you.
The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Thank you, counsel, for your patience. The next case we have this morning is 24-4100, NetChoice versus Brown. Counsel for Appellant, if you'd make your appearance and proceed, please.
Thank you, Your Honor. May it please the court, Erin Middleton, representing Attorney General Derek Brown and Division Director Catherine Haas. I'll collectively refer to both of them this morning as the state. This appeal is about whether the definition of social media in Utah's Minor Protection and Social Media Act is content neutral. The district court incorrectly concluded that it is not, and because of that error, it applied the wrong level of scrutiny to the entire act. This court should reverse that determination and the resulting injunction and remand for the application of intermediate scrutiny. Turning first to the content neutrality decision, the district court's holding that the Act's central coverage definition is content-based was wrong. A law is content neutral when it does not discriminate based on the topic or message discussed, or as Reagan said, when it is agnostic as to content. That is so here. The Act does not differentiate, the definition does not differentiate between any topic, message, or purpose discussed. It applies no matter what appears on a platform site. Rather than regulating content, the definition is instead designed to determine whether a platform contains certain structural features, just as Turner applied to cable companies of a certain size and Reagan applied based off of the location of signs. The district court focused on one particular element of the definition in its content-based holding, and that is whether or not a platform allows users to interact socially within that platform. The court focused on the interact socially phrase in particular. That focus on that phrase was wrong. That is not a content-based restriction. The term interact socially just refers to the fact that a site allows users to interact with each other within the platform. It does not regulate speech of any type of content, message, or purpose. The District of Florida recently looked at a similar law to determine whether or not it was content neutral, and I believe it got it right in the Uthmeyer case.
Counsel, excuse me. Do we have enough in the record to make a determination of what's content neutral and what's not?
I believe the court has enough in the record to make a content neutrality determination. I mean, that's a legal conclusion we've got.
But don't we have to do that on all of the different platforms that may be involved?
Well, certainly. Let me clarify my answer. To the extent the court is just looking at whether or not the definition is content neutral, I believe there's enough in the record to make the content neutrality determination on that. But I think Your Honor is right that once that determination is made that the definition is content neutral, that just opens the door for further inquiry because NetChoice has challenged several different provisions under the Act. And for each of those provisions, I think the court would have to look at those provisions to determine whether or not they satisfy content neutrality, and if so, what level, and then to apply the appropriate level of scrutiny. So I do think there are ultimately multiple determinations. The district court has not made those determinations. Its holding was based entirely on the definitions, and because the definition it said was content-based, it then applied strict scrutiny to everything without breaking it up into the individual challenges and conducting the facial analysis to determine what level of scrutiny applied, and then if so, determining, weighing their constitutional applications against any unconstitutional applications, and then weighing them against the rest. So I think all of that would have to be done by the district court, which is why we are just asking on this appeal for the court to make a determination on whether the definition is content neutral, and then to remand back to the district court so that those further proceedings can be held there for it to make those many determinations on the first instance.
Are you saying that there's just one issue to be decided, whether the definition is content neutral or not?
Yes, that is our
How can you possibly do that, given all the different platforms and the whole spectrum of platforms? It seems to me has to be examined.
Well, I think that's true to determine whether or not the act is unconstitutional, whether or not it fails whatever level of scrutiny is applied. But I think as far as determining whether or not the definition is itself content neutral, I think that can be done based off of the text of the statute.
Let me ask a question about the operation of the statute. As I understand, it limits the visibility of minor accounts. In your view, could a minor receive a friend request from an account with which it was not connected?
Yes, an RVO minor could receive a friend request from an account with which it is not connected. Just that minor's account name or handle, as it's sometimes called, can't appear in the mass search and indexing function of a site. So a stranger couldn't say, I want to see all Aaron Middletons in Salt Lake and have that show up. But if a requester knew my exact handle, then they would be able to send a friend request, and I could accept that request. A minor could accept that request without parental consent. But again, I think that goes to a separate question that goes back to one of the individual provisions of the Act and is a separate consideration from whether or not the Act is content neutral, whether that definition is content neutral, which is...
No, I understand that. I was just trying to understand more broadly how the Act functioned. And so I get that. Go ahead, please.
So looking at the district court's ruling on socially interact, it ruled that distinguishes websites based off of content. But as I was saying, I think when I started to answer Judge Kelly's question, that is not a content-based characteristic, because social speech can be on any conceivable topic, message, or idea, and the Act applies the same way. In that way, it is very much like the Reagan case, where yes, you maybe do have to look at the site or the platform to determine whether it has this functional capability to allow peer-to-peer or social speech. But beyond that, there needs to be no sort of parsing out to determine what types of things are discussed. So that satisfies the definition of, satisfies content neutrality, NetChoice has also on appeal argued that the Act is not content neutral because one of the other elements of the definition is that it regulates sites that display a list of users with whom the account holders share a connection with the system. I think that for the same reason as the socially interact, or the interact socially language, is also a content neutral functional qualifier within the statute that you look to see. Does the platform have this feature enabled? And if so, there need be no further assessment of that. It again is very much like looking at the signs in Reagan to determine whether they are on or off premises. And then the third
just pause, hit pause button, sure, and explain that a little more. What is it that they're claiming is content neutral in that situation, and why is it not?
Right. And so one of the elements of the definition is that it applies to a site. Well, under the definition, a platform must meet all 5 of these structural criteria in order to be a covered entity under the Act. One of those is the interact socially element that the district court focused on. NetChoice on appeal has then also looked at a separate element within that definition, which is whether it displays a list of users within the site with whom the account holder shares a connection. So just whether that list is displayed. So
okay,
if we're using common social media parlance, like your friend list is maybe a more colloquial way to explain that.
And it does not display your friend list?
If the Act does not have the feature to display that list of connected accounts, then it does not meet the definition of social media within the Act. So it looks at whether the Act has functional capability enabled to display a list of users, but it doesn't look beyond that, or a list of connected users for the content of that list.
And if it does have the ability, if the entity involved does display a list of connected social users, that is one criterion under which it falls under the Act, right?
Yes, if it satisfies, yes, that goes again to whether or not the definition covers the entity at all. That's separate from the issue Your Honor was asking about earlier as far as the default privacy settings.
Correct,
So
but if I'm understanding correctly, they're saying that the fact that is an element of content-based activity that the act would target entities that display the list of connected users. Is that right?
Yes, they're arguing that the definitions or identification as that as one of the structural features that an entity must satisfy. That they argue that does make it content-based.
Okay. And you're saying it's not? Why?
Why? I think this is very much like, again, the Reagan distinctions, that it goes to whether or not a platform has that functional element or a structure to display a list of connected accounts. So you do have to read the content just like you had to read the sign in Reagan to determine whether it was on or off site. But beyond that, looking to see if it was there is no content analysis that's required. It applies the same regardless of the nature of the types of entities or persons on that list. There's no sort of topic, message, purpose discrimination there. It's just, does it display a list of connected accounts or not? And that's the only thing to look at. I think it is like the off-premises, on-premises distinction in Reagan.
But it's a list of accounts of people. I mean, off-premises, on-premises strikes me as it could be viewed as a distinction with the difference between whether this particular entity displays a list of people who are socially connected. I mean, why isn't there some content overlay to that?
Well, the list isn't necessarily limited to people. I mean, it could be anything that any person or entity that is set up to be another account holder. It looks to whether or not the site allows them to be connected within the site and then displays a list of their connections. It does not reflect any sort of content discrimination as far as message, topic, or idea. It simply looks to whether or not there's the function enabled of, does it allow a display of a list or not?
Well, I mean, my question did focus on people. And as it relates to people, what I'm saying is, why isn't there some content dimension associated with whether you are displaying a list of people who are my friends or not? I mean, why isn't there a content dimension to that?
Well,
because you're regulating whether that entity can do that or not.
Right. It applies to an entity that does have that function enabled, whether or not, and it says whether they're connected within the system. So I don't think it's necessarily limited to friends. It's whether or not they share a connection within.
Okay. Well, they're connected within the system. Okay. I know I'm slow here, but I'm trying to, but help me to understand the point. And the point is, they're connected within the system. They could be people, they could be entities, but the point is, why isn't there a content overlay that you're trying to regulate because that particular entity chooses to display those people or entities with which I am connected? So give me the answer, the slow version, for why that's not a problem, okay?
Well, I think, again, because it goes to whether or not just that functional capability is enabled. It's not about discriminating between different subjects or messages or treating content differently. It's just about, does the act structure to allow this?
Wait a minute. I mean, that's not necessarily binary. I mean, the idea that, oh, it's functional or it's content-based, those aren't necessarily binary. I mean, you could have a situation where you choose to functionally have, somebody may choose to display certain content, and you say, functionally, I'm going to capture within my system any entity that displays certain content. So those two things aren't binary. They could, there's a situation where you could have functional structures in place that actually capture content. So what I'm trying to ask you is, why isn't this one of them?
And that's true. I mean, a function could be a purpose or could be discriminatory based off what Reagan said, but here it is not based off of the message or topic discussed. It only is about, does the act have the functional structure to enable the display of this list? It's not about any sort of discriminatory treatment based off of topic or message. It just looks to what functional criteria and structural criteria does a site have. With that, I'd like to reserve my remaining time for rebuttal, if that's all right.
Yes. Counsel?
May it please the court, Scott Keller for NetChoice. Utah's social media law violates the First Amendment in at least 5 ways. First, this is a content-based restriction on billions of posts of fully protected speech. Second, the parental consent requirement violates the Supreme Court's holding in Brown. Third, the age assurance provision imposes a barrier on every Utah citizen, including adults, to access these billions of posts of fully protected speech. That violates the Supreme Court's Free Speech Coalition decision. Fourth, the notifications ban is a doubly content-based speech restriction. And fifth, the display prohibitions, banning autoplay and seamless pagination, violate Moody, which recognized the First Amendment protects websites' decisions about how to display speech. Let me start with our argument of why this is a content-based speech restriction. And Chief Judge Holmes, I think you're exactly right, particularly on
before you agree with me, Mr. Keller, it strikes me that what brings us here on appeal is a much more limited issue than these 5 things that you're articulating. I mean, those are specific provisions within the Act, as I understand it. And the hard work of deciding whether specific provisions in the Act are content neutral or not is not necessarily what we're here to talk about now. And you can correct me clearly when I finish this statement, but as I understood it, the district court basically said that the definition of social media company is a definition that infects the entire Act with content-based, in an impermissibly content-based way. And therefore, in what the state of Utah says is, no, that's not true. And so now we're on appeal dealing with that one sort of limited question. And let's assume, I'm not saying it's going to be the case, but let's assume that Utah prevails. Well, you will be able to argue all the rest of this stuff in the district court at provision by provision. Then at least that's my conception of what we're doing here. Explain to me why that's wrong.
Yeah, I don't think that is the only thing the district court held here was, hey, this is content-based, I'm done. The district court had to apply heightened First Amendment scrutiny. And yes, it did apply strict scrutiny. And the state concedes here. If strict scrutiny applies, we win. And so we have joined argument here with the state on, we believe these provisions fail even intermediate scrutiny for many of the same reasons that the district court articulated under the strict scrutiny analysis. I mean,
yes,
the district.
But let me hit the pause button for a second. Yes, the court did apply the strict scrutiny and condemn the act to in that way to being unconstitutional. But I guess what I'm getting at is one decisional path that I see being invoked by Utah is simply that threshold determination that that definitional structure was content-based, which therefore infused the entire statute as being unconstitutional when the court applied strict scrutiny, that threshold determination was wrong. And then the question would be, as I understand it, should we engage on intermediate scrutiny here? So I could see that there could be 2 decisional things to do here, but what I'm trying to get at is that isn't necessarily what we have to decide. I'll stop there. Please,
sure.
Go ahead.
Judge Hunt, first of all, we do believe that this is content-based, and I'm happy to get into that. But even if you assume that we're wrong, I mean, we have both sides have briefed up whether these provisions fail or satisfy intermediate scrutiny. For instance, I don't know how the state can get around the holding of Brown that the state lacks, quote, power to prevent children from hearing or saying anything without their parents' prior consent, unquote. And I realize that the district court here rightly found strict scrutiny applied because it was a content-based law. But that's not the only provision of Brown that we rely on. The district court's heightened scrutiny analysis repeatedly relies on Brown to show why this law is both wildly under-inclusive, wildly over-inclusive, and also the fact that these websites provide parental tools, whether they're at the device level, the router level, the website level, the application level. Also, this law sweeps in.
Could I stop for a quick second? I understand I understand the virtues of efficiency, and it would be nice to wrap this thing up. But I mean, Judge Shelby is a smart guy, and why not? If we were to say Utah should prevail, why shouldn't we let Judge Shelby deal with these issues of intermediate scrutiny in the first instance? And maybe you'll win down there on everything. I mean, why not let it play out that way?
Well, a few reasons. First of all, we do believe this is content-based, but we also don't want to be in a position where we're having to run back and immediately go do preliminary injunctive proceedings anew. But let me tackle the content-based.
Can I interrupt just really quickly on that issue of sending it back to Judge Shelby, if we were to go that route? Did you read Judge Shelby's opinion in, I don't remember the footnote, maybe 26, as actually perhaps making a ruling on the intermediate scrutiny? The court basically said that nothing was given to the court from Utah regarding what supported the legislation in the first place, essentially, and that this wouldn't even meet intermediate scrutiny. How did you interpret that footnote?
Yeah, I think there are all sorts of parts of this opinion, including that, where all of those holdings were made. And this is why when the court says,
he didn't say it was an alternative holding. It just was sort of a bit of a stray comment. I wondered what your interpretation was.
Yeah, I mean, and the same goes to age assurance, that, this burdens all adults, not just minors. And the district court rightfully said this sweeps in much more. It burdens substantially more speech than would be necessary. And, strict scrutiny and intermediate scrutiny are both heightened First Amendment scrutiny with teeth. I mean, as this court has said, even under intermediate scrutiny, you need a close fit between the ends and the means. It still requires narrow tailoring. Regulating speech is supposed to be the last resort, not the first resort. Now, I do think the easiest way that this court can resolve all of this right now, though, is by finding that this is a content-based restriction of speech. I think it's at least for two reasons. First, the coverage definition sweeps in websites that allow users to interact socially, not just interact, but interact socially. And second, whether a website is covered depends on, do they provide a list of other account holders that are connections? And Judge Holmes, I do believe that this is absolutely content-based. You have to go look at the website, and if the website lists those connected users, it's covered. If it doesn't, then it doesn't satisfy that, it wouldn't be covered.
Yes, but it doesn't tell you anything about, it doesn't have any characteristic associated with the users. They could be any kind of users having anything they could be vendors, they could be individuals, they could be friends. So why is it necessarily content-based just because it instrumentally addresses users?
Well, I think you're still examining what is the substantive content, the speech that is on the website. Is there a list of users or not? But also, I think all of this goes to, Utah is essentially trying to exempt professional speech. And we also know this from the exemptions. This law exempts email, it exempts cloud storage, it exempts document collaboration. All of those would be professional speech. And I think the Western District of Texas and the Southern District of Ohio and the CCIA versus Paxson and Yost decisions did get it right in finding that these are content-based restrictions.
But let me hit the pause button for a second. I mean, on this notion of restricting professional speech, I take it that the Facebooks of this world would be captured by this provision, right? By this act.
Yes.
A lot of people do business on Facebook. A lot of people do, and when I'm trying to focus on whether this thing is content-based, what I'm thinking about is that there are all sorts of content on the internet, and there's all sorts of content that would be within the context of Facebook. Let's just use that example. I mean, where is the content restriction when you could have every flower blooming on the internet and you can have every flower blooming on Facebook? I mean, where's the content discrimination there, including the business part? Because I mean, I know there's some entities, that's the only place they do business is on things like Facebook. So where's the discrimination there?
Well, I think it would be the other types of services that would have these same, online sort of, whether it's autoplay and pagination. We've given examples of how this is over-inclusive and under-inclusive, that, it covers Dreamwith, which is just about creative writing, even though they don't use autoplay and seamless pagination. But then Services like ESPN and Disney Plus and Hulu and Spotify and the New York Times are not covered, even though they would use that. Also, I think the district court was completely correct here that the state hasn't even tried to show a direct causal link in the harm that they purport to allege.
But I'm
websites.
focusing on the definitional aspect now, the socially aspect, which I thought we were talking about, and the notion of whether that's sorted by content. And what I was trying to get at is you can talk about anything socially. One, two, that the entities that are captured within and without this act both appear to be engaging in the same sort of speech. I mean, so in other words, the notion does it excludes the internet? Well, the internet is doing all sorts of content. In this, what's covered, they're doing all sorts of content. They could talk politics, they could talk sports, they could talk business within the scope of the act too. So why is it targeting anything?
Well, so I think first of all, it's not just interaction, it's interact socially. And I think the word socially has to have some meaning in this statute, or else it would be superfluous.
And
now,
tell me what meaning it has that distinguishes it between, let's say I leave a comment on the New York Times Facebook page, or I leave a comment on ABC News, I know would have a Facebook page, and I leave a comment on there, I'm angry about blah, blah, blah. I mean, I'm interacting with ABC, right?
Well, I believe it's interacting with each other, as in the other users on the website. But look, I think if there's any vagueness about this, I don't think you can hold that against the websites. The state has to draw a law with sufficient specificity. And so it's not just interaction, but also too, Judge Holmes, even if we go the other direction and say, well, there's a bunch of other websites that allow the same thing, but those aren't covered, I think that's just a huge tailoring flaw for this law on the state. And I know that doesn't necessarily go to strict scrutiny versus intermediate scrutiny, but it does go to heightened First Amendment scrutiny under whatever standard applies. And I think that's why the Supreme Court in Packingham and in Moody said those laws and those provisions challenged, they sustained those challenges even under intermediate scrutiny, saying we didn't have to get to strict scrutiny because the laws wouldn't survive even the lower form of intermediate scrutiny. And we know from FEC...
And that goes to whether you win if even under a circumstance where Judge Shelby was wrong initially. And that's the threshold question, it seems to me, that we're called upon to decide, is whether this definitional content-based dissemination was wrong, right?
I do think it's content-based because of the distinction between professional speech or news or entertainment. If you disagree on that, though, I would also submit that the Supreme Court has made clear this is.
I'm the guy asking questions. I'm not agreeing or disagreeing with anything right now. But go ahead, please.
Can I interrupt just to make sure? Is there anything besides what you just said, which is that it distinguishes based on not just interacting, but interacting socially? Is there anything besides that really makes or breaks your argument?
With that, it's a content-based restriction. The second would be the displaying the list. The third would be reading this all in context. I think the exemptions of email, cloud, and document collaboration, I think that bolsters our argument that what Interact Socially is trying to get at is making a distinction of professional speech versus social interaction. Those would be the three.
And yet professional speech can also be, I mean, you can make professional speech on any of these social media websites, right?
I think the best way to read Interact Socially is that's what the state and the law was trying to get at. And we know this isn't just interaction. I mean, there are all sorts of ways, of course, to interact. This is interact socially. But even if your honors disagree with everything I just said, at pages 37 to 50 of our brief, we have given all of the alternative basis to affirm on the individual provisions. This is the parental consent provision squarely foreclosed by Brown. The age assurance provision targets billions of posts of fully protected speech. The notifications provision says that websites can't engage in their own speech. The autoplay and seamless pagination bans directly infringe the editorial judgments of how to display speech. And I think the district court was correct here. This isn't like a Moody situation where there's a dispute among the parties over what is covered by this law, and the defendant concedes that at least intermediate scrutiny applies. And so these laws are going to raise the same First Amendment issues in every application. And this is a law that is doubly narrow in that it targets social media companies operating social media services. So this is not like Moody, where the court said, well, we don't know about direct messaging, we don't know about ride sharing, we don't know about payment services or online marketplaces or email. All of those kinds of websites that Moody flagged could have a different First Amendment analysis when you're talking about compelling more speech dissemination. None of those are covered by this statute. So there's no Moody facial challenge problem, and this law is unconstitutional in various ways. I see my time has expired. If there are any other questions. Thank you, Your Honor.
Thank you, counsel. You have a little bit of time left, I think, Ms. Middleton.
Yes, just responding to NetChoice's argument sorry, do I need to wait for the timer?
I'm sorry. Yeah, I did. You
I
have some
expected
time?
it.
I thought you did.
Yeah, I think I had.
Okay, 27. a huge 27 seconds. Okay, go ahead.
Responding to NetChoice's argument that the Act exempt or treats professional speech differently, there's simply no basis in the Act for that. Email, cloud storage are very structurally different sites than a social media site, and communications on either of them could be about anything. So that's not a content-based. And as far as Brown goes, that's a case applying strict scrutiny in a content-based regulation. For those reasons, the state would ask the court to reverse the district court's holding that it's content-based and its application of strict scrutiny and remand.
All right. Thank you, counsel, for your fine arguments. Case is submitted. We have one more case to hear this morning, and it is 25-4013. And I know I'm going to butcher the appellant's name, so I'll say it anyway. Szymakowski versus Utah High School Activities Association, 25-4013. Counsel for appellant, you can correct me on the name, pronunciation, and then proceed, please.
Sure, Your Honor. I think you were quite close. It's my understanding is Zachary Szymakowski, but in any event, I'm Craig Perry, and I represent the appellants and defendants below the Utah High School Activities Association and its board of directors. Now, this case involved the high school sports and two students who were restricted from varsity competition. The emotion of the rush to let an Australian punter play one game led to a decision that the UHSAA was discriminating against foreigners. With no such finding by the district court, appellees nevertheless devoted entire sections of their brief to arguing that the rule emanates from xenophobic animus and fails rational basis review. The mere fact that appellees found such positions worthy of two sections of their brief perhaps tells us that even they think rational basis standard is the correct adjudication. And that is what the UHSAA seeks here. We ask the court to reverse the district court's decision and remand the case for further proceedings consistent with the appropriate standard of review. I'd like to make...
Just to clarify, if we think that the district court incorrectly applied strict scrutiny but should have applied intermediate scrutiny, you lose. Because your position is only rational basis can we support.
Well, our position is that rational basis is correct. Now the court...
I'm asking, if we disagree with that, what is the result?
Well, if you would agree that strict scrutiny applies, then I think you just affirm the lower court.
Right. What about intermediate scrutiny? Because
the intermediate's it's a little bit more complicated because the court held that it applied strict scrutiny, and that's what it said.
I understand.
But then there was also statements that said the record does not show that the rule survives heightened scrutiny,
right?
Let alone strict scrutiny. So
I'm just asking. I read your brief as just basically arguing only that you survive only if we agree with you that it's a rational basis standard.
I think even if you were to apply a heightened scrutiny, a intermediate, that it should still be remanded, because I think it was more in passing and dicta that the court said. I don't even think it would be intermediate. So I still think the court should make findings that say this fails intermediate. But clearly, if you feel strict scrutiny is appropriate, then that's the end of
I
this.
understand. Okay, thank you.
And by court making findings, you're talking about the district court, right?
Yes.
Okay.
All we're asking this court to do is determine the level of scrutiny and determine whether or not it violates, and we're asking that it does not violate, it's not preempted, doesn't violate the supremacy clause. And so I think first I'll turn to the supremacy clause and just give you an overview of our arguments there. The lower court and appellee's almost exclusive reliance on one sentence from the Decanus and Toll case, that any state enactment that imposes a burden on aliens not contemplated by Congress is preempted, is misplaced. Neither of those cases purports to create a new category of preemption, what appellees seem to call the additional burden. Indeed, the analysis of both of those cases framed the additional burden analysis in terms of a conflict between state and federal law, which as the court knows, along with express preemption and field preemption, are the three types of preemption recognized by the Supreme Court in this circuit. No case, neither Toll nor Decanus that includes that statement they rely on, concludes its analysis with a simple determination of whether state statutes constitute an additional burden. So this is a conflict preemption case. And as this court held in the Choate case in 2000, conflict preemptions are where it is impossible for a private party to comply with both state and federal requirements, or where state law stands as an obstacle to accomplishment and execution of the full purpose and objectives of Congress. And this court continued in that case, conflict preemption requires that the state or local action be a material impediment to the federal action or thwart the federal policy in a material way. Now, a law affecting a F1 visa student's participation in the extracurricular activity of varsity sports does not conflict with federal law. Federal law on F1 visa holders says nothing about participating in extracurricular activities. Rather, an F1 visa provides non-immigrant aliens the right to temporarily enter this country solely for the purpose of pursuing a full course of study, which the regulations define as study in a curriculum to consist of class attendance for a number of weeks to make normal progress towards graduation. And the ordinary meaning of curriculum is the courses offered by an educational institution. Participation in extracurricular activities, including varsity athletics, is simply not part of the congressionally defined course of study. The word extracurricular itself denotes that it is outside the curriculum. So the second point is on equal protection. In the last summer's holding by the Supreme Court in Spinelli, I believe, ends the discussion about whether F1 visa rule classifies on the basis of alienage and is therefore subject to strict or heightened scrutiny. The UHSA rule classifies on the basis of visa status, not alienage.
Well, isn't that just trying to play with the words?
No, it's not, because
come on. F1 is only for aliens, and the educational experience clearly includes extracurricular activities, whether it's specifically said or not. And to say that we're going to keep all foreigners out of here who have F1 visas is clearly, as one of your coaches said, I want to be able to read the names of the players. That was the big problem.
Well, two things. One is in Spinelli, as this court knows, the only people affected by the law were transgender youth.
Not even closely analogous.
But in this case, the only people affected by the law are aliens.
Foreign aliens.
F1 visa
That's
students.
right.
And in the Geldug case, yes, and in the Geldug case from California, the only people affected by the law were women. But the court in Geldudig and the court in Spinelli said that because there is not an identity of interest in other words, they're in the California welfare case that denied welfare benefits to certain pregnancy conditions. The court said that the law created two classes of individuals, pregnant persons and non-pregnant persons. And because women were in both groups, it was not a law targeting women, and therefore rational basis applied. In Spinelli, the law, even though the law affected only transgender individuals, there was transgender individuals seeking certain types of puberty blockers, and then there were all other people, and transgender people fell on both sides of the law. Therefore, there was no identity of interest, therefore it did not classify on the basis of sex. In our case, you have one group that is F1 visa students, and the other group is all other foreign students. J1s, H1s, everyone else is not affected by the rule. So you have aliens in both classifications. And under the Supreme Court holding, that the conclusion of that is that the law does not classify on the basis of race, on alienage, excuse me.
Well, this is, as far as I'm concerned, you're taking on the high school students, and you're saying that because you're from out of the country and you're here on an F1 visa and you kick good field goals, we're going to prevent you from playing. To boil it right down to the nitty gritty.
Well, that might
there's not field goal kickers on both sides.
I'm sorry, but I understand what you're saying, but to me that just gets to the analysis. Is there a rational basis for this? Is there racial animus?
That's the rational basis, is that you want to win more games without foreign students on the other team.
No, because there are many types of foreign students that this rule doesn't even affect.
Oh yeah, those that don't play any sports.
No, this rule affects only one type of visa holder that is particularly susceptible to being recruited.
And so concisely tell us what the rational basis is for this law. That
the rational basis is that part of the association's goal for the past 100 years is to create a level playing field and equal opportunities for people to play. F1 visas, because they allow a school to reach out to a foreign individual, entice him to come to the school and immediately play sports through the remainder of his career, make that situation susceptible to recruiting, whereas other students like H1s, J1s, and others, they can't be recruited because they can't pick their school.
Why isn't it? I thought I heard you refer to a level playing field. Why isn't it still a level playing field? Every school in Utah that's within the scope of your organization can recruit, right? Why can't they recruit like anybody else?
Well, because recruiting is forbidden by our rules, so we're trying. This is an enforcement mechanism to try and ameliorate recruiting, but it's also a difference between private and public schools. Public schools can only have an F1 student attend for 1 year. Private schools can have them attend till graduation. And the thing to keep in mind, this does not prevent them from playing sports. It just puts conditions on their varsity eligibility. They can play sub-varsity. Most kids who go to high school don't have the opportunity to play varsity sports for one reason or another. Academic eligibility.
Yes.
Who are you trying to create a level playing field for?
Well, it's just for all the
non-aliens?
No, it's for them too, because like I said, that aliens are allowed to play. And in fact, J1 aliens have fewer restrictions than local students. If
the schools are going to recruit, which I understand is prohibited, but you're suggesting that's what they're doing and you're trying to enforce it in this way, don't they recruit? Don't private schools recruit all the time from out of state? They get somebody to come move into Utah and bring their family there, and then they've got some out of state folks that aren't, aren't Utahns either. I mean, I'm just wondering who it is you're trying to protect in this level playing field.
Well, we're trying to, again, this is the rational basis analysis, I think, that should be conducted by the district court. But
are you trying to protect the public schools?
We're trying to
private schools, because private schools, if they're recruiting, I mean, they may be recruiting from a lot of places, not just F1 visas.
No, they are, but it's a purpose, a goal of the association to minimize, to deter recruiting. I'm sorry, go ahead. No, to keep athletics in perspective in regards to the other functions of a high school.
Well, my point is this: how will this keep them from recruiting from, other states, other locations, even within this country? How would it possibly go to any other recruiting besides this recruiting?
It doesn't. It addresses one type of recruiting.
So how does it really create a level playing field, which was the one interest that you cited or basis that you cited?
Well, I don't have time to explain all the harms of recruiting. I mean, level playing field, I guess, is one, but it's also in the way these recruits are treated when they come here. There was evidence before the district court of their mistreatment that was acknowledged by both the judges. So
rather than have mistreatment, you just won't let them play at all?
No, they're allowed to play. There's just restrictions on them.
Oh, but they can't be in tournaments and they have to get approval, right?
They can't play at the varsity level. They can play at the sub-varsity level, or the school can choose to go independent, as schools have chosen, or they can choose not to play in a state tournament. So it does restrict them, but it doesn't prevent them from playing.
And Mr. Perry, let me make sure I understand the relief that is being sought here. What beyond the preemption issue, let's say we find that this particular provision is not preempted. Okay, beyond that issue, you would just seek our determination that this is not subject to strict scrutiny, and then send it back to the district court. Is that right? Or
no,
should we go ahead?
Seek a determination that it's subject to rational basis. I mean,
rational basis, and then send it back for the court to work out the rational basis analysis.
Yeah, let them work out all these questions you're asking about, whether it's whether it makes sense, whether there's other ways to do it to fit within the rational basis analysis. That's all we're asking this court to do.
Okay, I just want to be clear. Thank you.
Okay, thank you.
We'll hear from Appellant. Please proceed.
Thank you, Your Honors. May it please the court?
Yeah, please go ahead.
May it please the court. My name is Tanner Camp from the law firm of Foley & Lardner. I represent Zachary Szymakowski and Joanna Uribe on behalf of her son, Felipe Uribe. If the UHSAA gets its way, no F1 student attending high school in Utah will ever play in a postseason game, stand on a championship podium, or hold up a championship trophy. Fortunately, the Constitution prevents the UHSAA from getting its way. As this court knows, there are two issues here: preemption and equal protection. With respect to preemption, plaintiffs are likely to succeed because the UHSAA admitted that the rule imposes burdens upon F1 students beyond those imposed by Congress. With respect to equal protection, plaintiffs are likely to succeed because the rule is subject to at least heightened scrutiny, and it fails under that standard.
Well, we can start with preemption, and opposing counsel pointed out that we have a long history of we and the Supreme Court have defined what preemption means, and there are three categories of preemption, and the one is not added burden. And so why is that enough that there's an added burden if that added burden is not deemed to be within the doctrine grounds for preemption?
Your Honor, I agree with opposing counsel that those are the general categories of preemption in when you're talking about preemption generally and whether federal law preempts state law. However, none of the conflict preemption cases that opposing counsel cites in their brief deal with regulations that discriminate based on alienage. And we have a direct case from the Supreme Court that does deal with state regulations discriminating on the basis of alienage. And this is what that case said. This is the Toll Moreno case. Quote, state regulations not congressionally sanctioned that discriminates against aliens lawfully admitted to the country is impermissible if it imposes additional burdens not contemplated by Congress, end quote. I understand that opposing counsel wants to draw back to other areas of preemption law that don't directly deal with state regulations burdening or discriminating on the basis of alienage, but the Supreme Court has told us what the burden is here. And that makes sense, Your Honor, because immigration and naturalization, dealing with aliens, that is an area of law that is constitutionally granted to Congress. And so when you have a state regulation that is discriminating on the basis of alienage and that imposes additional burdens that Congress didn't envision or impose, that is preempted.
Well, any burdens, or how severe do the burdens have to be? What are we talking about? What renders it unconstitutional or preempted, for a better word? Right.
I think that the best way to answer that question is to turn to Toll v. Moreno itself, Your Honor. And there we had G4 visa students, or excuse me, G4 visa holders. And the court there said that Congress had not imposed domicile restrictions on that set of visa holders, right?
And in fact, Congress had contemplated that they would be able to be domiciled, right?
Contemplated that they would be able to be domiciled by not imposing restrictions on them. That is exactly the case here, Your Honor.
Well, but hit the pause button. The language of that case spoke of what Congress contemplated, and what it contemplated was that they would be able to be domiciled somewhere in order to fulfill the purposes of the visa. Is that not right?
Your Honor, I don't think that's exactly right, because I think what happened in Toll v. Moreno is Congress put restrictions on other types of non-immigrant aliens and said that they could not satisfy the domicile requirements. It did not put those same restrictions on holders of G4 visas. It was silent on that issue. That's the same thing that we have here, Your Honor. For F1 students, Congress has allowed those students to enter into the country to study at a high school if they meet certain conditions. Those conditions being they have to speak English reasonably well. They have to pay their own way. They have to intend to return to their home country when they're done.
And pursue a course of study. And it does say nothing about extracurricular activities. And so why should one assume that in some sense that is not, that the states are not left, as they are on most things in educational matters, to decide how to address that?
Well, Your Honor, I think that when you're saying to pursue a course of study, that's correct. They are admitted to pursue a full course of study, but that doesn't mean that they are disallowed from participating in all the other types of aspects that are part of the high school experience.
Does Congress really care whether I can do debate team as a F1 visa holder? I mean, why is that a matter that relates to my course of study?
I think that, Your Honor, the fact that Congress did not preclude these students from being able to participate in those activities shows that, yes, they intended that those students should be able to participate in every type of opportunity that domestic kids can participate in high school. And, Your Honor, it's interesting to note, where would it end? If a state can preclude students from participating in high school athletics, can they stop these students from going to lunch?
I recall that example, and let me say that whole question raises another whole constitutional issue. I mean, there are a whole range of constitutional issues that could arise if they stop some kid on the grounds of alienage from eating lunch and those sorts of things. That's not what we're here to talk about now. What we're talking about is whether this particular provision would be preempted, right?
And the answer to that, Your Honor, is that, again, Congress did not say anything about this. And in fact, if you look at Appellants cite the regulations that deal with J1 visa holders, for example, saying that those students, the regulations say that they can participate in athletics. That's not exactly what those regulations say. Those regulations, and there are much more of them with J1 students, they say that they can participate in athletics if allowed to do so by the school district and by the state athletic association. The fact that they did not put that type of restriction on F1 students suggests that they actually didn't want to have any restriction on F1 students for playing and doing athletics and other extracurricular activities. And that's because F1 students are closer to regular domestic attending high school students. J1 students are limited to 2 semesters attending school. And so it would make sense that Congress would have those different regulations.
Mr. Camp, let me just ask 2 clarifying questions. One, so are you saying that the traditional framework for preemption does not apply here? I mean, in other words, are the conflict preemption cases irrelevant to analyzing your claim?
I don't know that I'd go as far to say they're irrelevant, but I would say that we have a more specific case that gives us our direction, and that's Toll v. Moreno.
So you stand or fall on Toll v. Moreno then?
Well, Your Honor, whether you would like to call Toll v. Moreno a conflict preemption case or not, whether those labels matter, I can't really say, but.
Oh, they matter. Historically, they matter. So what I'm trying to understand is, would we be offending your claim if we looked at least for guidance, the traditional conflict preemption cases in deciding whether you win or lose?
I guess I would say I don't think those cases will be very helpful because, again, appellants have not cited any of those conflict preemption cases that are dealing with state regulations discriminating on the basis of alienage.
And that leads me back to my initial question then. Are you saying that if we don't find that Toll allows you to win, then you lose, right? Are you standing and falling on Toll then?
I think that Toll provides the preemption standard for our situation. That's correct.
Okay. Then the other clarifying question, a little less complicated maybe, is you on the fundamental rights area and in terms of whether there is heightened scrutiny here, one thing that I wasn't clear about in the briefing is, are you saying that is there a fundamental right to play varsity sports, or is there a fundamental right to play postseason varsity sports? What are we talking about?
I don't think we frame it in terms of fundamental rights, Your Honor. It's a fundamental right not to be discriminated against on the basis of alienage.
Well,
right?
the issue is what's the impact? I mean, what's the impact in terms of what are you being denied the right to do? And that determines whether there's discrimination on the grounds of alienage. And I'm not trying to make light of your claim. I'm just trying to understand because I mean, theoretically, the F1 visa holders can play varsity sports. They would forfeit any right to play postseason varsity sports. So is the ground of concern or grievance the impingement of the ability to play postseason varsity sports, or is it varsity sports generally because the schools will just not let you play if you're going to have that impact on their team?
I think it's the latter, Your Honor. This forces them into a Hobson's choice, right? A varsity team into a Hobson's choice to choose. Okay, are we going to let this F1 student play on our team, which would force our entire team to forfeit postseason play? Or are we going to just say, you know what, it's not going to work out. We're going to have to go forward because it wouldn't be fair to the rest of the kids on our team. And functionally, that excludes all F1 students from varsity play.
Got it. Thank you.
Now, I want to return back to something that Judge Moritz asked Mr. Perry about. If we disagree that rational basis applies, you lose. I want to correct something. The district court did find that strict scrutiny is the correct level of scrutiny. However, the court applied intermediate scrutiny. It applied a heightened scrutiny and found that under the heightened scrutiny, the law fails or the rule fails. And that's important to remember. So let me just talk a little bit more about the equal protection. State classifications based on alienage, like those based on nationality or race are inherently suspect and subject to close judicial scrutiny. Now, in the alienage context, the Supreme Court has recognized two exceptions. The exceptions that don't apply here, a political and government function exception and regulation of aliens not lawfully admitted to the United States. State classifications that fit under those exceptions are not subject to strict scrutiny. As this court knows, there is a circuit split regarding the existence of another exception, the regulation of non-immigrant aliens. But the Supreme Court has never recognized this exception, and neither did the district court. Like I said, it applied a heightened level of scrutiny.
It's a pretty lopsided circuit split, isn't it? I mean, you have one case, I think the Second Circuit, and everybody else on the other side in terms of how they deal with non-immigrant aliens. Isn't that right?
I wouldn't think it's not as lopsided as the other side has proposed it to be. First, they claim that it's the Sixth Circuit, Fifth Circuit, and 11th Circuit on one side versus the Second Circuit on the other side. The 11th Circuit case really isn't applicable here, Your Honor, because there it was dealing with DACA students or those who were not lawfully admitted into the United States. It falls into a recognized exception within the Supreme Court analysis. It's not
DACA students have a legal status, though, do they not?
Well, the students in that case in the court went to say that they were not aliens who were here lawfully admitted. And so
right, what do you do with the Skirmetti argument then? I mean, the reality is that the argument would be, anyway, and the one articulated by opposing counsel, is this cannot be discriminating on the class of alienage, since there are F1 visa holders on one side and there are all other aliens and citizens on the other side. And so how can that be a discrimination based upon the class of alienage?
So I think that what's most telling about opposing counsel's argument is what he did not cite. And that is Nyquist versus Moslett, a Supreme Court case that is directly on point and dealing with alienage again. There was a New York law that barred certain resident aliens from state financial assistance for higher education. And the state there argued in part that the statute did not classify based on alienage because it distinguished, quote, only within heterogeneous class of aliens. It did not, in other words, it did not distinguish between citizens and aliens. And the court rejected that argument. And it said this: you classify based on alienage when the regulation, quote, is directed at aliens and that only aliens are harmed by it. The fact that the statute is not an absolute bar does not mean that it does not discriminate against the class, end quote. That clearly shows that this is discrimination, classification based on alienage. And these other cases dealing with sex, the intersection of sex and medical conditions are not applicable, Your Honor.
All right. I think the time is up for both of you. No. If you have a question.
Well, I just wondered if you could address the Plyler case, where the Supreme Court applied an intermediate scrutiny to a case involving undocumented children. Does that impact your analysis at all as far as what the minimum level of scrutiny might be here?
Yes, Your Honor, I think it does. And I think it's an important observation and distinction to make. As Your Honor said, in Plyler, the court applied a heightened form of scrutiny when dealing with a class of aliens who are undocumented or here illegally. Now, this is something that the Second Circuit pointed out with the absurdity or the irrationality of what the Sixth and the Fifth Circuits have done, because they've applied a lower level of scrutiny to regulations that are discriminating against lawfully admitted aliens here on a temporary basis.
But an issue in Plyler was the right to be educated at all. I mean, it seems to me that's different than than any sort of claimed right to play football. I mean, in during play varsity sports. I mean, those are two different things, aren't they? I mean, it's the question of what is the deprivation? I mean, what are you being deprived of, right?
Well, Your Honor, the UHSAA itself says in their handbook that these high school sports and extracurricular activities are essential to the high school experience. That's the words that they use, essential to the high school experience. And yet they're denying something to these F1 students that they claim to be essential to this experience.
All right, thank you. Any more questions? All right, thank you, counsel, for your fine arguments. Case is submitted. Court will be in recess until call.
Thank you very much.